Tēnā koutou katoa. My name is Cindy Robinson and I'm the chair of the hearings panel for the proposed Timaru district plan. We're resuming this week with hearing F, which is quite a detailed list of matters, but generally described as other district-wide matters, hazards and risks, but natural hazards only. Before we introduce the panel, I'll invite Commissioner Solomon to.
Ki ngoi tātou, good morning everybody. Kia tātou katoa, te atawhai o tātou ihu karaiti, me te aroha o te atua, me te whiwhi nā tahitanga ki te wairua tapu, ake, āmene.
I'll begin with
I'm Jane White. I'm a Commissioner with a background in planning.
Stacey Scott, Commissioner, Timaru District Councillor.
Raywin Solomon, Independent Commissioner.
And just before we begin, I just want to acknowledge too that we have a number of submitters presenting online today, and there's a number of people joining us online, so welcome to you as well. The panel would also just like to address an update on conflicts of interest. The participants in the hearing will just be aware that the panel issued a minute 31. It's 31. Just noting that our hearing support advisor, Ms. Thorne, is the author of a Section 32 report that has formed part of evidence on behalf of Kiwi Rail, and for that reason she will not be assisting us in relation to the noise chapter of the district plan, and we'll just keep that separate. And I'll just run through other conflicts. Thank you.
I am a submitter on the West Coast district plan in relation to natural hazard matters.
And the position that the panel has reached is that Commissioner White won't participate in questioning, deliberations and decision making on the natural hazard aspects of that, and we'll keep that separate as well.
I have a new conflict and a perceived conflict with Julia Crossman from Opua. She has recently joined a St Pat's Junior Netball Committee that we're on together. So I just wanted to let you know that.
Panel's just simply noted that on our register of conflicts, and there's no issue from our perspective in relation to that.
And I don't actually think I have a conflict. I do work part-time for Te Taumotu Runanga, and I have worked for Kaikoura Runanga for a number of years. My current work for Taumotu doesn't involve planning, it doesn't involve resource consents. I just do project management at the marae.
And again, these matters will just be noted on our register, and I'm satisfied that there is no further steps we need to take in relation to Commissioner Solomon's interest disclosure. The updated conflicts register will be available on the website. So, I think that's probably all of the housekeeping matters from my perspective. I'll hand over to you, Ms. Wheeler. Thank you.
Thank you, Madam Chair. Tēnā koutou ko Jambella Aho, legal counsel for the council, and the panel will have a set of legal submissions from me that follows the general format of my previous legal submissions, but I've also just handed up, hopefully, as I did at the last hearing, a bit of a snapshot in a table in terms of who the council's sort of experts and council officers are and where they are, whether they're online or in person. But I might just start by introducing the council team. So there's 4 Section 42A reports in relation to this hearing. The first is the Natural Hazards, Coastal Environment and Drinking Water Protection report prepared by Mr. Willis to my right. The second is the Light and Noise report prepared by Ms. White. The third is the activities on the surface of water, public access and versatile soils, and that's prepared by Mr. McLennan. And the fourth one is relating to earthworks, relocated buildings and shipping containers, signs and temporary activities. And that was prepared by Ms Rachel Williams, who was Willicks at the time of filing the report. And the panel she hasn't appeared before the panel before, but she's a council planner. And each of those, well, not all of them, but most of the 42A reports have attached to the back of them evidence or memoranda from specific experts. And those experts are online at the moment, with the exception of one. So in relation to the coastal environment chapter, we have Mr. Derek Todd from Jacobs, who's a coastal and hazard scientist, Mr. Cyprian Bossarel from NIWA, who's a hydrodynamic scientist, Ms. Yvonne Pfluger, who has appeared before the panel before. She's a landscape planner from Boffa-Miskell. In relation to the natural drinking water protection chapter, we should have Mr. Hall. Is Mr. Hall here? He's not here at the moment, but hopefully will be at some point. But we can certainly make sure that he is if you have any questions for him. And Mr. Neil Thomas, who's a groundwater hydrogeologist from PDP for drinking water. And then Mr. Kevin Kemp has provided a memorandum in relation to the flood assessment overlay for the natural hazards chapter. He's not actually available today, but he will be here tomorrow to answer questions if necessary. For the light and noise report, Mr. Hunt, who's an environmental noise specialist, is online. And for the signs chapter, Mr. Logan Copland and Ms. Jeanette Ward, who are transport planners from Abley, are also online. So I might, as per usual, the 42A authors have also prepared summaries with the tables attached at the back that identifies outstanding issues that have arisen or been resolved as per the evidence that's been filed. And so at paragraph 11 of my legal submissions, I just set out there the issues that these submissions address, and they relate to, there's not a lot in here to be honest, but they relate to the versatile soils chapter, drinking water protection, and the flood assessment area overlay. And I'll also just pick up on a couple of other things that have arisen in the legal submissions and evidence that's been filed since, but I'll come to those at the end. So I turn to paragraph 12 on page 6 in relation to the versatile soils chapter. I really just wanted to set out here the approach that the council or that Mr. McLennan has taken in terms of his recommendations to that, because the PDP was notified before the NPS HPL came into force, but there are quite a few submissions seeking that the plan be to give full effect to the NPS HPL. But of course, we're in a bit of a transitional period under the NPS because we're awaiting essentially the RPS to identify what the areas of highly productive land are, and once that happens, then the district council is under an obligation to change its district plan and objectives and policies and rules to give effect to the NPS. In the meantime, the NPS still applies and the council must give effect to that through the decisions that it makes. But I don't think there's a specific obligation to use this process to fully give effect to the NPS HPL. Having said that, it would be inconvenient and inconsistent for the versatile soils chapter to go ahead as it is currently. It would be inconsistent with the NPS. And so Mr. McLennan has taken an approach where he's tried to align the versatile soils chapter with the NPS so that it's not inconsistent, but in doing so acknowledging that it's not fully giving effect necessarily to the NPS because a separate process will come once the RPS mapping has been made operative. And I think that's quite important because there are certain obligations in the NPS, for example, to give effect to the NPS in consultation with tangata whenua, and that hasn't occurred yet. And it also enables the community to participate in an all-inclusive Schedule 1 process that allows them to identify how to give effect to the NPS at a local level. Because of course the NPS has quite prescriptive measures in it, but there may be local flavours that can be incorporated into the PDP to give effect to it. In terms of, if I turn to paragraph 22, again, this really just sets out, sort of for completeness and just to support the approach that the council has taken towards the drinking water chapter. And the reason I've set these out really is just to clarify again that this council has jurisdiction to control land for the purposes of water quality. So while water quality is sort of perceived to be a regional council jurisdiction, and the regional council obviously controls takes and discharges, it's still within this council's jurisdiction to control land for the purposes of water quality. And that's really bolstered, I suppose, I think in terms of the provisions of the Water Services Act, and in particular, amendments that were introduced to the RMA, which is 104G, by the Water Services Act, which makes it clear that the territorial authority has a role in relation to the impact of land uses on drinking water supply sources. And so I don't plan to go into that in any detail, although I do note at paragraph 32 that there, as Ms Francis from ECAN has identified, there is an overlap between the PDP rules and the regional plan rules in some instances. And so the council and Mr Willis are mindful of the fact that the panel has interrogated, I suppose, those potential overlaps in other contexts in other topics. And Ms White has made recommendations as far as she can to avoid those overlaps in those other topics. But in relation to this one, both Mr Willis and Mr Hall have considered that and nevertheless considered that it's appropriate that those overlaps, that there is that overlap, and the reasons for that are set out in this 42A report and Mr Hall's evidence. So turning to paragraph 36, and this is in relation to the flood assessment overlay. And the issue that arises here is that Environment Canterbury made a submission that the flood assessment overlay was essentially too narrow and should be expanded. Unfortunately, they didn't provide a map with the submission, and so it was a general submission that the mapping should be expanded, but it wasn't clear as to what that expansion, they thought that expansion should be. This council's relied on ECAN's advice and evidence as to what that should be, and we think that's appropriate given ECAN's role in relation to natural hazards and in particular the information that ECAN provides to district councils for that purpose. But the potential issue that arises is, in the absence of actually providing a map, excuse me, is there a natural justice issue? And of course, the panel has asked that question in relation to a number of other topics, so we've given attention and thought to that. I think there's a few factors to consider in that regard. In particular, I think it's in determining whether there is one. Firstly, there is clearly scope in the sense that, to make the changes in the sense that the submission sought an expansion of the mapping. So there's no issue around whether the type of relief being considered by Mr Willis is within scope of what was actually requested. The issue is really, did people who might have been affected by the expanded mapping have the opportunity to participate, given there was no map to determine whether or not you were in or out? But I think in considering that, it is relevant to consider what the burden on individuals who might not have had that opportunity would be. And Mr Kemp's evidence and Mr Willis's evidence is that in relation, there's two parts to the flood assessment overlay. One is the urban areas, Timaru and Geraldine. One is the rural areas, and there's a slightly different approach that's been taken to identify the overlay in each of those areas, and that's because in the urban areas, the council has a stormwater system, and that alters how natural flooding might occur or might not occur. And so the district council holds that information and has worked with Environment Canterbury to develop the flood assessment overlay based on advice from their external and modelling from their external consultants. ECAN has provided the mapping for the rural areas. In terms of, so the obligation is to, if you're in the overlay, to go and get a flood risk assessment, and that's going to help to define, in relation to habitable buildings, for example, what your minimum floor level might be. In relation to subdivision, there's a requirement that your building platform's not in a high hazard area. So the cost of that in the rural areas from ECAN, so you go to ECAN to get that in the rural areas, that flood assessment, the cost of that is $150 to $200. And Mr Willis's assessment is that that's not particularly onerous. In the urban area, because the modelling is sort of undertaken and held by an external consultant, it's a bit more expensive, so it's $650. But Mr Willis's view there is that it's better to have mapping that's more accurate than not. And so the refinements essentially justify adopting the new mapping. And in terms of numbers of people affected, I've set that out at paragraph 42. In the rural areas, it's around 1,600. In the urban areas, and these are just estimates because it hasn't been possible to get very, very specific about the numbers, but in the urban areas, it's around 300. But the overall reduction is, so there's been a large reduction in the number of properties captured in the urban areas, but a slight increase in some areas. So there are around probably 2,000 people that would be affected by the new mapping versus the PDP mapping. But what I haven't addressed in here, because it was a thought that I had post filing submissions, is that even if the notified version of the PDP mapping was retained, there might be those 2,000 people, for example, outside of that who, according to ECAN, ought to get a flood risk assessment. Those people, I think, would nevertheless be caught by the Building Act and the Building Code requirement to, the performance standard is something along the lines of, you need to make sure that in a 1 in 50 event, water can't enter the building. So you'd still need to go and figure out what your 1 in 50 event leads to in terms of a minimum floor level. And so there's still some cost involved in that. And my understanding is that you essentially go through the same process as if you were in the overlay. But the overlay requires, in accordance with the RPS, to give effect to the RPS, an assessment of the 1 in 200 event. So that's why we're not leaving it to the Building Code and the Building Act to deal with that altogether. To give effect to the RPS, it needs to be by reference to the 1 in 200. And a couple of other points that are relevant to your consideration set out in particular at 43, is that the flood assessment overlay didn't draw a large number of submissions in the first place. So there's about 10 submissions on it. And I noted that Ms Francis's evidence says that a similar process was effectively followed by both Selwyn and Waimakere Council, and there hasn't been a requirement to re-notify those maps. I did try and have a look at whether those decisions considered the issue, and from memory the Selwyn District Plan decision didn't, but the Waimakere District Plan decisions haven't been released yet. So I think from the perspective that whether the ECAN mapping's adopted or the PDP notified mapping is adopted, there would be a cost for those for individuals in any event to assess what their appropriate minimum floor level would be, whether that be under the PDP or under the Building Code. I'm more comfortable, and the council's more comfortable, that if there is any natural justice issue, it's quite small. The additional burden is small. But if the panel is still concerned about that, I've set out a couple of options for you. 45, paragraph 45. So, and that's assuming, of course, that you accept that there's merit in the proposal to adopt ECAN's mapping. If you thought there was merit in that proposal but were concerned about the fairness issue, one option might be to essentially notify that further information that's been provided by ECAN, and that would really be essentially like a public notification process, because it's too difficult to get down in detail quickly as to who specifically is affected, and indicate that you would allow late further submissions on that. If you were to follow that approach, we would really need to do that reasonably quickly so that we can wrap up any further submissions and any further assessment by Mr Willis in hearing H. And of course, your other options are to reject the submission but recommend the council undertake a variation because the panel doesn't have the delegation to make that decision itself, or simply reject the submission altogether. And I think I would say that this council's sort of left in a bit of a tricky situation as a result of these circumstances, but their reluctant preference for cost reasons and delay reasons would be to incorporate it into this process if that's possible, rather than do a separate variation later. Yeah. Yeah. Yeah.
Just on that, like you say as an argument as to a small natural justice issue that there were only 10 submissions that were in response to the notified version, but of those submissions, a number of them take the opportunity to identify specific characteristics or issues property. And my concern would be that effectively you've taken away that opportunity for those 2,000 other submitters by expanding the overlay. And I just wondered if you had a comment on that in terms of natural justice.
Yeah, I think my comment would be that the overlay itself it's not a flood map. It's not saying these areas do flood. It's saying it's sort of, I think Mr Griffith's evidence openly admits that it's saying it's a reasonably broad brush map that identifies areas that could flood in a 1 in 200, and for that reason a more detailed assessment is required. And so what the submissions are asking for is essentially that more detailed assessment, which can't be done at this stage or hasn't been done at this stage. That's the approach that's been adopted. So it's really just it's a trigger for a further, more detailed assessment of how to address a potential flood risk.
Has the council given any consideration to whether or not there's efficacy in having essentially an alert layer for those sort of additional newly mapped areas as opposed to having a regulatory trigger?
No, I don't think it has. I don't think it has, although I'm kind of struggling to figure out on the spot how that might be different, because in a way this is an alert layer of a kind to that triggers as I said, a more detailed assessment. So we'd need to give some further thought to whether or not there was sort of a middle ground or a step down from what's currently there at the moment.
Might like to give some thought to that.
Thank you. And so I mentioned at the beginning that I'd pick up on a couple of issues that were raised in legal submissions and evidence. I'll start just with flagging a potential issue in relation to the Kiwi Rail requests. And this picks up on the 100-metre setback from the railway designation boundary that was the subject of your minute 30, I think, from memory. The evidence, I think, of Ms Hepplethwaite contains an appendix which seeks the specific amendments being sought in the evidence. And that refers to the 100-metre setback being from the designation boundary. Through the other evidence, the term railway corridor has been used. And I think from memory we had some discussion in hearing A around what those various definitions are: railway line, railway corridor, etc. The rule itself refers to railway line, and the original submission of Kiwi Rail in its relief sought essentially strikes out the 40-metre setback and replaces it with a 100-metre setback. But it doesn't alter the terminology. So the term railway line is still left in there in terms of the relief sought. They haven't sought to alter railway line to railway designation or railway corridor. And so I guess what the council's seeking is actually clarification as to what Kiwi Rail are asking for, and that is likely to come through in the maps that you've asked for as well. But also flagging that if what they're seeking now is a setback from the designation boundary, there may be a scope issue there, but it's hard to tell that until we actually see those maps. And then, of course, there's the merits question that Ms White can address, but essentially our understanding is that the issues in relation to noise and vibration come from the use of the line itself, rather than the use of the designation boundary itself, but that can be explored with the witnesses. And just for reference, the original Kiwi Rail submission points that I looked at were points 73 and 74. That's not their submission number, that's the reference in their table to their original submission if you wanted to go and have a look. And then in relation to the Department of Conservation, Council filed some late further legal submissions yesterday afternoon. I received those and then got in the car to travel, so I've had a quick look at them, but just thought I'd give some initial thoughts. The issue that arises there is that the current rule relating to the use of jet boats on rivers but both in terms of the notified PDP and in terms of what Mr McLennan is recommending, has a temporal restriction that, from memory, is something like August to February. And the reason for that is to protect fish spawning. And DOC have then came back in their evidence and said, actually, there are issues in the complete opposite time period, so from February to August, and I may have those mixed up, but in relation to bird habitat. And we would like that temporal restriction changed. So essentially the evidence is asking for exactly the opposite of what's in Mr McLennan's recommendation and the PDP. So the issue is that the original submission from DOC supported that rule, so it supported the temporal restriction that is in the PDP and carried through into Mr McLennan's recommendation. But the evidence seeks the exact opposite of that. So Council has drawn on my previous analysis from, I think it's the Hearing D reply submissions, and lands on one of the general principles that you, in order to determine scope, you sort of review the entire relief package sought in the submissions, and concluded that there is scope because for that amendment, because there's some general discussion in relation to the objective of some policies that raises issues in relation to the habitat of breeding birds, and the submission on the rule itself talks about an appropriate times of the year, but ultimately it supports what was originally there. So I think it is a little bit problematic, given that they've supported the PDP, for them to now turn around and say, well, actually, we've changed our mind and we don't support that anymore because of bird habitat reasons. It leaves me feeling a little bit uncomfortable around scope. Council does, though, make what I think is a reasonably good point, which is that the Jet Boating New Zealand Association is party to this, and particularly party to that rule. And so I imagine that they'll probably have something to say about whether there is a potential natural justice issue, but if the affected parties are already involved, I'd be more comfortable about the scope issue. But I think that's probably something that needs a little bit further exploration. And another scope-related issue is the one raised by Prime Port in relation to Ms Williams' recommendation on the signs rule. So the issue there is that in the notified version, there is a separation distance for signs, but there's no limit on the number of signs that you can have along a road frontage. And so there are some submissions that sought to remove that minimum separation distance, and Ms Williams accepted that, but she thought that in conjunction with no limits on the number of signs on a road frontage could potentially result in an over-proliferation of signs. So essentially there'd be no control. And so she's recommended to remove the minimum separation distance, so accept those submission points, but in order to avoid the situation where you could have signs everywhere with no controls, put a limit on the number of signs on a road frontage. And so my reply submissions for hearing E set out the kind of scope in terms of what consequential amendments, and essentially you can make those if they logically arise from the relief sought, but they need to be reasonably foreseeable. And so the question really is, would it be reasonably foreseeable to have some additional sort of controls? If you're going to take that control off, is there another way of doing it? And if you look at it from the perspective of that common articulation of scope, which is, you know, is it somewhere in the line between what was notified in the PDP and what the relief sought was? I think you could probably argue that it is as well. But I think the real issue is just identifying what's the appropriate control on those signs. So in terms of the merits, this is obviously thrown up an issue for Port because they've got a long road frontage. So in terms of the merits, is that appropriate, or do you need some further tweaks to that? So I think that's probably where the focus really should be. And then lastly, I just wanted to pick up on the submitter for 22 The Terrace. The issue that arises here is that the Port has sought during the consultation process for the draft plan, sought a Port outer noise control boundary, and that's come through in the PDP and applies to 22 The Terrace. And that has some requirements around acoustic insulation and that kind of thing for residential buildings in that outer noise control boundary. The evidence from 22 The Terrace contains an assertion by the landowner that requiring insulation will essentially deter residential development in the city centre zone. And in turn, that would mean that the objectives of the city centre zone to create a vibrant city centre where people want to come and live won't be met. There's no expert evidence provided around what the potential impact of requiring insulation in that area might be. It's just an assertion from the landowner. And then drawing on that evidence, Council has made a submission that effectively that means that there's a breach of Section 71, which is the provision that says your rules have to implement your policies and objectives. I'm sure Port will have something to say about this too, but I think that's quite a bold submission to make, particularly in the absence of any expert evidence on, the economics or planning implications of that. And particularly, I think you could probably argue, in the absence of evidence to the contrary, argue the other way, so that people might actually be deterred from living in that area if you didn't have acoustic insulation. So I just don't think that we can make an assumption that that Section 71 is breached or those objectives can't be met on the face of the evidence that you have in front of you at the moment from that landowner. And just as a matter of detail, but just wanted to pick up as well, in the legal submissions of Council, paragraph 13, D2, which is on page 6, there's a reference to the landowner evidence, Mr Gresson, and says that Mr Gresson and others he has spoken to that live or work in the buildings on the terrace have not and do not experience noise effects generated by Prime Port Timaru. But the evidence, on my reading of the evidence anyway, Mr Gresson appears to have spoken to the businesses that exist in his building at the moment, but there doesn't appear to me to be any evidence from about conversations he's had with people who live in that area. And of course there'll be a difference between businesses and daytime noise and residential living and nighttime noise requirements too. And just lastly, to pick up on the suggestion in both the evidence and the legal submissions that the Port has a vested interest. And so the Port has prepared the analysis that supports the noise control boundary. And so there's a suggestion from the submitter that the Port has a vested interest, and so effectively you shouldn't put weight on that. But I think that's the way that the noise control boundary was identified is that during the consultation process, Port identified that they think there is one necessary, and so they went and did the work to prove that, or to show that that's what would be appropriate, and the council's reviewed that and accepts that. And it was prepared by an independent expert, so I don't think there should be any concerns around, the Port's vested interests. It was prepared by an independent expert in the first place, reviewed by the council, accepted by Ms White in terms of her recommendations. So that's all I have, unless you've got some questions for me.
Thank you, Ms Wheeler. We can move now to Mr Willis.
Thank you.
Thank you, Madam Chair and Commissioners. So, apologies again for the complex and lengthy report. I think I've got the record for this hearing for the longest Section 42A report. There's I guess there's part of that is that there's quite a lot in the natural hazards chapter to cover, and also coastal environment, which covers natural hazards as well as coastal environments, character matters, and then there's the drinking water protection. But yes, this will be the longest, but it's also my next report before the panel won't be anywhere near this length, which is good news. So in my summary, I've identified some key issues raised in submissions and also covered in evidence, and that's just before the panel today, certainly in terms of evidence. And the first one to bring to your attention is in Section 3, which is around Maori reserves, and Waipopo huts in particular being located in areas subject to flooding. The Port of Timaru is obviously in an area that's subject to natural hazards, quite rightly so, given that it's interfaced with the sea. And it's about getting a set of provisions appropriate for that activity, noting its location. The definition of natural hazard sensitive activity and how best to reword that to capture what we want to capture, but not what we don't. The extent of the flood assessment area overlay, which Ms Vella has already raised with you today on the basis of ECAN's evidence. How to provide for and enable natural hazard mitigation works, how best to do that. The duplication with ECAN in terms of drinking water protection and the rules in the Canterbury Land and Water Regional Plan. How to take into account industrial activities that are already within drinking water protection areas and providing for those or not going forward. There's some evidence raised from telecommunications companies around their infrastructure in relation to natural hazards. And I'm just reading some of the highlights here on my way through my summary. There's still some questions around the coastal erosion overlay in the vicinity of the port and the location of that, based on ECAN evidence and also evidence from the port itself. Clarifying jurisdiction of councils in relation to the beds of lakes and rivers for drinking water protection. And then ECAN has provided some extra information through their evidence around how to manage overland flow paths and refer to those in the natural hazards provisions, and dealing with diversion and displacement, and changes to the flood assessment certificate wording. And there's a specific submission before you and some evidence around Harvey Norman and flooding on that Harvey Norman site. And probably the only other one I'd raise of those issues raised in the evidence which floats to the top for me is around whether regionally significant infrastructure should be considered similarly to the Crown and the councils in relation to natural hazards mitigation. I have provided some updates to my recommendations from paragraph 13 onwards. I won't read those out, but I think a lot of the suggestions from the submitters and evidence are reasonable, and so are many of the others, although I haven't yet turned my mind to the detail on some of those, and I may well seek further information from the council and experts around giving effect to those. One thing I would note at the outset here, and that isn't clear in my 42A report or actually in the chapter, and this is in relation to the submission from and evidence from Al and Ms Crossman, and also Ms Irvine for ECAN, is that under the Canterbury Regional Policy Statements and under the RMA, both district councils and regional councils have dual responsibility for managing natural hazards. And the Canterbury Regional Policy Statement specifies that it is the regional council and not the district council that manages natural hazards within the beds and margins of lakes and rivers. So the district plan provisions, natural hazards chapter should really include a statement in the introduction to say that these do not apply within the beds and margins of lakes and rivers. And with that in mind, I think that would resolve at least one of the issues raised by Ms Crossman on behalf of Al in relation to duplication with the Canterbury Land and Water Regional Plan, because the rule that she refers to in her evidence is limited to the beds and margins of lakes and rivers, where these provisions would not apply. So that would resolve the issue of duplication. And I note Ms Irvine refers to a code of practice for managing natural hazard mitigation works, and that code of practice is limited to the beds and margins of lakes and rivers as well. So the district plan provisions would apply outside of that. So there is not duplication in that matter, and I thought I'd bring that to the panel's attention at the outset. Thank you.
Sorry, Mr Willis. I'm talking about your section 42A report. At paragraph 8.3.5, if I've understood properly, I think F and B also sought for the coastal policy statement to be acknowledged or recognised in the introduction of the CE chapter. As it has informed numerous CE provisions, do you consider that warrants being acknowledged in the introduction?
I guess fundamentally there's a lot of higher order documents that could be acknowledged in each chapter. I don't think it's necessary to do so because there are a number of those that apply. So I mean I think that that would apply in terms of, I think there's a general statement around how the plan works which would refer to the statutory context, which identifies various higher order documents in that, and how the district plan is required to respond to those. So I don't think it's necessary.
Okay, thank you. At your paragraph 8.14.6, I agree the policy is about natural values, but would you agree that some cultural values are natural values? For example, peka peka, Ngāi Tahu Taonga species, Indigenous biodiversity, and kaimoana. Can these, they're natural values, they're natural cultural values. Would you agree with that?
Potentially, yeah. Ms Pfluger does cover that in her response to the submission as well, saying that where they are clearly natural values, they could be included. I guess I took a reasonably blunt approach in my response here by saying that a cultural value or an associative or I guess an anthropocentric approach is not necessarily a natural value. So I appreciate that they're on a spectrum and that there is potentially some overlap there. I was quite blunt in my response.
Okay. Sorry, just bear with me. I'm a bit all over the place here. I've got a question for Ms Pfluger. Is she online?
My understanding is that she should be.
Morning, Ms Pfluger. Can you hear me?
We can't hear her.
Okay, she can't.
That's all right.
Maybe I'll ask the question anyway. Okay. Under the CRPS, under policy 12.3, it says local authorities will engage with Ngāi Tahu as tangata whena to identify the values of cultural significance associated with outstanding natural features and landscapes as part of detailed assessments. This is with regard to landscape assessments. And this process will be assisted by iwi management plans. The the Bofumiscal landscape study did not engage with mana whenua, nor was it assisted by IMP, because it was not part of the Bofumiscal brief, as I understand it. Instead, the study relied on Ngāi Tahu claim settlement information and statutory acknowledgement information. Would you agree that engaging with mana whenua and being informed by IMP would have grounded the settlement and statutory acknowledgement information and give it local context?
Can you hear me now?
Oh,
Yeah.
sorry.
Did you hear the question?
Yes, I did. Yeah, thank you. So while it was a combined study, the landscape and the coastal study, they were sort of separate processes in a way that happened concurrently. We did have a review at the time, and I've provided that to Ms. Bella previously, and I can look that up from Ngāi Tahu. My opinion is, I think the closer the engagement can be, the better the study will be, and I'm sure that there are better ways to do this with more input. So we just had to draw on the sources that were available to us at the time, but there was a review process as part of that as well.
Okay. Have you read Ms. Beard's her replies to the panel's question, Ms. Beard from Heritage New Zealand, where she says accidental finds are usually found in rural and coastal areas and in already modified areas? Does it change your landscape expert view about earthwork provisions you have commented on?
I haven't read that particular submission, but I think there are two different things. There's the landscape and there's the natural character. And natural character relates, the natural character is higher the less modification there is in a particular environment. So generally, where there's more modification, the natural character would be lower. And a lot of the differentiation regarding the rules happen based on areas that are within the coastal environment but outside of high natural character areas. And then there would be a higher consenting threshold around the areas that have high natural character. And that was based on the fact that the level of modification generally is higher within the coastal environment that haven't been identified as those H and C areas. And in regard to your question, and that's how we structured the earthwork rules to allow for more earthworks within the more modified parts, whereas it's very restricted within the high natural character areas where the natural character could be compromised through earthworks more readily. So in relation to your question, if those potential fines would be within areas that have been modified previously through settlement or other uses, that, in my view, doesn't fall under natural character. It's a different sort of aspect. I'm not saying that it shouldn't be covered, but I don't think it should be covered under natural character because it generally would relate to a level of modification that would be almost contrary to the natural character. So I think while cultural values are very important, that in that instance probably don't relate so much to natural character.
It's probably a question I shouldn't have asked you. I should ask perhaps one of the planets, so apologies for that. Just two more questions, Ms. Pfluger. To appease my curiosity, I'm talking about wind turbines here. Do you think small household turbines attached to rooftops, in your view, for those types of wind turbines, would that go through a permissive consenting pathway? do you think that should go through a permissive consenting pathway?
Well, we had a specific response as part of my memo regarding the wind turbines. I think with turbines, there are several aspects. So one is the disturbance that you have from building them, and quite often you've got earthworks to then build, the concrete footing for those and the access to that area. And then you've got the permanent effects that relate to the turbine, and that relates to the size, in particular to the height, but also the blade width. So some turbines, and the ones that you're referring to, that can be installed on dwellings, they're generally very small, they're not very high, and then their blade width is generally quite small. I think the effects of those are definitely lower than the general commercial sort of wind farm turbines they're becoming higher and higher over the years, which can be hundreds of meters high with very long blades. So I think there's a differentiation between the two, and also if the turbine is mounted on a building, then you don't have those effects that relate to the construction and to the foundation of the turbine.
Thank you. And now on to solar arrays. Why
Yes.
are solar arrays, from a landscape perspective, why are solar arrays more acceptable on buildings than standalone frames?
So it's partially a similar response to the wind turbines. So solar arrays generally don't need a concrete footing. It depends a little bit on the soil, the way they are being constructed. Quite often they can just be put straight into the ground without necessarily requiring a foundation. If that's the case, then you can actually remove them, and the effect after removal would be the same. If that's not the case, and often if there's a wetter ground, you will need some sort of foundation. Then there are more permanent effects if you come off an existing structure. So on an existing structure, from a landscape perspective, I don't consider that there's a particularly high landscape natural character or visual effect, because you already have that modification in the landscape anyway. Whereas if you, I guess the natural character of pastoral land would be higher than of already sealed surface or a building. So that's why I consider that the natural character effects would be higher if they are, if solar panels are being installed on currently pastoral land.
Okay, thank you. Now I've got a couple of questions under drinking water protection areas. And this is for you, Mr. Willer. I refer to your paragraph at 9.5.4, DWPR5. Is the reason it's non-compliant to develop land within the overlay and the MPZ is because industrial and rural activities occur in the MPZ?
So Madam Chair, I'm just trying to find that reference. Just give me a moment. 9.5.4. And can you please repeat that question, sorry?
Is the reason it's a non-complying activity to develop land within the overlay in the MPZ is because an industrial and rural industry activities occur in the MPZ?
I think it's not an issue of the MPZ per se. It's simply that industrial activities anywhere can create issues on drinking water protection. Except in this instance, we've provided the district plan provisions as amended acknowledge where that industrial activity already exists, and those activities already exist, which provides a pathway for where it already occurs and is zoned. These industrial activities don't necessarily occur in rural zone or the MPZ as of right. So it's not about the zone per se. about the fact that those activities can cause drinking water protection issues.
So I'm really picking up on Ngāi Tahu's submission.
Yes. Yes.
Because when I read that, I couldn't quite understand what they were saying, but then I think I've understood it.
So, Madam Chair, I think my understanding is that Ngāi Tahu's submission is that we should be allowed to have whatever activities we want in the Māori purpose zone, and these restrictions limit that ability, and we don't think that's appropriate in the Māori purpose zone. I believe that's the thrust of the submission, and my response to that is drinking water protection is important and should apply in all zones, irrespective of whether that's a Māori purpose zone or not.
So I'm reminded by your paragraph 139 and your strategic objectives, the S42A report, where you say the reserves were set aside for a purpose,
Yes.
and I do not consider it appropriate to subjugate activities on Māori reserves to these other activities. To do so could constrain achievement of the purpose of the Māori reserves, and I note the existence and location of Māori reserves is a matter of public knowledge. I may not be understanding properly, but is it just to impose on a race of people onerous development requirements because of effects created by other activities, particularly within the context of how the reserves came to be and their original intent?
I think the starting position is that unless there's a good reason to manage activities that might conflict with the intended purpose of the Māori purpose, unless there's a good reason to do so, then we shouldn't be, because those areas were set aside for a particular purpose. In my opinion, drinking water protection is a life risk issue, and it's important to be managed, and it should be managed consistently no matter whether it's a Māori reserve or not a Māori reserve and who's drinking the water. That's my view. So while my starting position is we should enable Māori purpose reserves to be used for the purposes for which they are set aside, in this instance I think it is appropriate to restrict certain activities for the protection of drinking water. And you'll see that I've come up to a different determination in relation to natural hazards for the Māori purpose zone. I thought that was on the other side of the line in terms of what was appropriate.
I appreciate what you're saying.
Yes.
I just have that map in my mind with all the overlays, and it feels like the purpose of the zone is being captured in those overlays. They're in the crossfire. It's in the crossfire of those overlays. So I was just trying to understand.
Also I think there's also submission from Waipopo Huts Trust, although I'm not clear on that, around the council providing reticulated services as well for drinking water in that location. So I guess there's a question around who does provide the water in that location and for the community as well. And if we are providing, if there is water, water must be provided in there for those residents, and it should be safe, in my view, for drinking. And I think that's an appropriate restriction then, if that's the case.
Okay, thank you.
Yeah.
Thank you. I think my questioning is actually for Mr. Kemp, just around his report with regards to Harvey Norman.
Sure.
Because some of the evidence that was given by Harvey Norman's is basically saying that they think the data is negligible. Mm-hmm. And so I wanted to talk to him, so I'll talk to him tomorrow just on his views on that and whether he thinks, well, obviously he doesn't think that's true. So I want to be able to flesh that out with him. So I've got questions for Mr. Kemp.
Sure.
My other question to you is just around the Waipopo huts as well, and it's in Mr. Rob Kerr's evidence. He suggests that the likelihood of inundation is overstated by ECAN, and I just wonder your views on that, because obviously I think it's sort of following on from the same topic, is it overstated and with all the overlays? So it's in his conclusion actually, Mr Kerr's conclusion, the site is subject to flood hazard. However, I'm concerned that the likelihood of inundation is overstated by the ECAN assessments.
Sure. I mean, from my perspective, Commissioner, that's more of a technical question that's probably better asked of the technical experts, Mr Kerr, and also and Mr Griffiths, I note, is appearing for ECAN and had some involvement in support around preparing that report that I referred to from ECAN in terms of the risk. And I think that's probably more of a technical question for either of those to respond to.
A non-natural hazard question. It's just a matter of clarity for me going forward and potentially help me either ask or not ask some questions of ECAN. In your summary, point E, to further clarify how gravel extraction in the beds of lakes and rivers is managed in response to the ECAN evidence, and I note that's probably in response to, I'm assuming, Ms Irvine's matters. Can you just clarify, the further clarify that you're thinking about, appreciating you haven't done the detail, is that around the kind of reducing duplication and things? Is that what you're thinking, or are you thinking something else? And if it's something else, can you tell me what that might be?
Certainly. So I guess I'd approach that submission points in looking at what is the jurisdiction around those activities in the beds and margins of lakes and rivers. And my understanding is that the council has duties and obligations for managing drinking water. And my understanding is that could extend into the beds and margins of lakes and rivers. So applying a jurisdictional approach, I think both councils have responsibility. However, it's a bit more subtle than that, the ECAN submission. What the ECAN submission, I think, is what I'm reading now on the basis of Ms Irvine's evidence is that, well, yeah, that may be the case, but this is not a question of jurisdictions. We already have a land and water regional plan which quite clearly manages mining and quarrying specifically for those activities in that location and considers drinking water protection as part of that. So there's a question in my mind of, it's not necessarily a jurisdiction issue anymore, it's more of a duplication question in relation specifically to mining and quarrying in that location, and within the confines of that location and activity, is it appropriate that the district plan says mining and quarrying is managed except where it has a regional council consent under the plan. So we could probably work our way through that in terms of duplication matter then, rather than a pure jurisdictional issue.
Thank you, that's helpful.
Thank you. Thank you, Mr Willis. I just wanted to ask you a question just in response to an issue raised by Ms Crossman and her evidence around your agreement to amend policy or NHP 3 to reference including native habitat.
Yes.
And I just, whether you've had a chance to consider her thoughts on that and what your response to that concern is.
Yes,
Sorry, it's her 4.123.
Yes, I met with Ms Crossman last week, and I think the language in there is a little bit blunt, I think, because it's the vegetation, not habitats per se. It's the vegetation component, and it was simply in my mind was saying some vegetation which provides flood hazard management is also native, and that's essentially what I had in mind. But I think that could be dialed back to refer to vegetation rather than habitats per se, or for fauna, for instance. So it's flora that could be reduced to, or alternatively I could dial that back and not include it anymore. But fundamentally in my mind when I approach that, it's simply saying some vegetation which provides natural hazards mitigation is native, and I was just simply clarifying that. But I think Ms Crossman's correct.
You could just say vegetation.
Yes, should just say vegetation, yeah.
Thank you. And also just wondered if you could help me, and it may be that some of these questions are best addressed by Mr Griffiths in his ECAN evidence, but I have to admit I'm just struggling a little bit about the approach to modelling of the flood overlay, particularly in the rural zone. I think Mr Kemp has done a reasonably good job of explaining the urban context in his evidence, but I'm not clear on what the starting point is in terms of the flooding overlay, in terms of the annual exceedance probabilities, whether there has actually been modelling or mapping done based on a 0.2
2% or is it just 0.5%? So that's my first question, and then I have some questions about how that translates into how the rules then work with the mapping.
Yeah, I think that is a question best posed to Mr Griffiths in terms of how he's gone about doing that, creating that new overlay, which he has covered in his evidence, but potentially not the level of detail that you're in relation to that particular matter that you're asking.
But in terms of planning evidence, I mean, it's your role to evaluate, part of your role is to evaluate in terms of Section 32, the rule framework that applies. So I'm interested to know what is your understanding of what the overlay encompasses.
So my understanding is the overlay identifies areas that might flood, not necessarily areas that do flood.
At what probability?
I think Mr Griffiths has applied the RPS 200-year requirement because that's what the RPS requires.
But the RPS also requires an avoidance around high flood
does.
risks.
Yes.
So how do we know whether or not the overlay includes or excludes high flood risks?
Yeah, I think my understanding is that Mr Griffiths has applied LIDAR and elevation and worked out sources of rainfall and where that water could track. I'm not sure the level of detail he's got into in terms of which particular event that he's considered as part of that. It's simply saying this area could flood and we would need to do a flood assessment in detail to work out the level of flooding and under which event that would occur in that location. It's my understanding that it's broader than applying, because I think it's very expensive to do detailed flood modelling in an area the size of Timaru, and especially also in areas that you may never need to do detailed flood modelling because no one actually has any intention of developing. So there's a question around efficiency of ratepayer funding for doing that work, whether it's not actually necessary to do. So it's more responsive, I guess. This area could flood, and if someone proposes to do a development, we would then look at it in more detail and apply our understanding of various modelling information that we have, rather than doing a detailed modelling map for the whole of the district, which may never be necessary.
Have you discussed with Mr Griffiths or satisfied yourself about the degree to which the overlay may either under-capture or over-capture flooding risk across the district?
Yeah, Mr Griffiths covers that in his memo, and it's a judgment. And I think that's probably where one of the issues lies. Is it overly conservative? Is it under-capturing or is it over-capturing? And where does the benefit apply in that situation? And from my perspective, over-capture is not overly burdensome when the cost of a flood assessment certificate is in the order of $150 to $200, and potentially you would need to do something similar anyway under the Building Act, irrespective of whether it's in an overlay in a district plan, simply to manage any building that you would put in that location. So I think from my perspective, it's not overly burdensome at that cost, and given that you would need to consider flooding anyway, even if it wasn't in the district plan under the Building Act.
You think Mr Griffiths will be able to help us in terms of risk potentially for under-capture?
Yes, he does cover that in his evidence.
Okay. Just reviewing the Council Section 32 report for natural hazards, you'll be familiar with that. There's a table in there that reviews plan responses in other districts. Best practice is 1.4.7, other council approaches. Just in terms of the the flooding risk aspect and the default to effectively require consent applicants to undertake the evaluation themselves to determine what their activity status is. Is that a commonly accepted approach, or is it limited due to the size of this council and the cost of the modelling work?
So I don't have that section 32 up just yet, but if you're asking a question around, is it the general approach of doing a flood assessment certificate approach rather than mapping an entire district in advance and setting out areas that are different? Yep. Yes, it is a common approach. So that's an approach that's been adopted around Canterbury anyway, to adopt that approach. The Christchurch City does something similar. Waimakariri does it, Selwyn does it, and Kaikoura has adopted that approach too. Again, it's inefficient to map an entire district at the level of detail required, especially if there is no development that's going to occur anyway in that valley or that location, because it's rural zoned with a minimum subdivision site size of 20 or 100 hectares, for instance.
We received, I don't think they're appearing at the hearing, but we received a written statement or correspondence on behalf of Alliance Silver Fern Farms, and they indicated a large level of agreement with what you're proposing, but they were also critical of and they referenced the 0.2% AEP and they, as a trigger, and say that best practice is usually around the 1% or 0.5%. Did you give some thought to that, and what would be your response to the concerns that they've raised?
Yes, so there's differing levels of AEP that are applied depending on, I guess, the jurisdiction in terms of which district and which region, but also whether it's under the Building Act or the Resource Management Act. And the Canterbury Regional Policy Statement is quite clear around which AEP to apply within the Canterbury context. And for just general flooding purposes, it is the 0.5% AEP or the 200-year flood event. And then it also identifies a high hazard, which is a 0.2, but it's not just anything that floods in a 0.2 event. It's depth times velocity greater than or equal to 1 metre in that event. And I think there's a lot of confusion around that. It's not just simply does it flood in that event, it actually needs to be more than a metre or less than a metre if it's moving at speed. And so the context for the approach here is that it's required or mandated to be in the Canterbury Regional Policy Statement, which this plan gives effect to.
Don't accept the concerns that they've raised.
I acknowledge those concerns, and it may well be that other jurisdictions have a lesser AEP that they apply. In this instance, we're applying what's in the Canterbury Regional Policy Statement, which we have to give effect to. And I have come across in my career frequently arguments around, the Building Act requires 50-year flood level, or sometimes the Building Act is interpreted to apply 100-year flood level, which it is in parts of Canterbury, I understand. And is that not sufficient? And my response to those criticisms is principally that the Building Act applies to a single building, whereas the district plan applies to communities and also applies to council infrastructure and other assets that are at risk, and that there are more consequences than simply to one building on one individual site when the whole area is flooded, and that it is appropriate to consider something more than a Building Act, and we can do. And so that's generally the approach that I take. So I acknowledge their comments and concerns, but I think there's not a lot of room to move within Canterbury because of the RPS.
Thank you for that. I'll just double check that I've picked up everything. That's fine for now, thank you, Mr Willis, and I don't have any questions of the other council witnesses on this topic at this point. I probably should have said at the outset that the panel's sort of going to avoid asking too many detailed drafting type questions as we pick them up, and as we work through those, as we've done in other hearings, we'll issue a minute and request some feedback on
Sure.
any
Yes.
drafting exercise.
Thank you, that's helpful.
Thank you.
Thank you.
Thank you, Madam Chair. I'll ask Ms White to present her summary.
Good morning. My topics today are noise and light, so two district-wide chapters. I guess just in terms of my summary statement, I've outlined the key issues that were identified in the Section 42A report, but probably a number of those have essentially fallen away in terms of what is still live in the evidence that's been received. So just in my summary statement at para 4, I just list the ones that there is still some evidence received in relation to. So in terms of the recommendation to include some lighting controls in the long-tailed bat protection area overlay, there's still some evidence in relation to the specific controls in that area. There's evidence in relation to the introduction of a noise control boundary and related suite of provisions for Fonterra. I do go on in my summary statement to say that on the advice of Mr Hunt as well, we've essentially agreed with that. The only outstanding areas of disagreement are kind of matters of drafting in terms of policy and activity status. There's an outstanding issue in terms of port noise, but again, that's having reviewed the evidence submitted, I've agreed that there's a gap there that needs to be addressed. So again, that's no longer outstanding. And then at 4D, I think is probably one of the key outstanding issues. It relates to what area acoustic insulation requirements should apply to in respect of the state highway and the railway line. And at E, what the actual acoustic insulation requirements that should be applied. Just in para 5, there are a number of other, I guess, less key issues, but nonetheless identified in evidence. Inclusion of a new specific rule for lighting at Fonterra's site. Again, I have accepted the appropriateness of that. There is some evidence around the wording of light 01 that's outstanding. There's a small matter of whether congregations within places of worship should be added to the definition of noise-sensitive activity, so that is to do with when noise insulation is required. There's still an outstanding issue as to the application of the port outer noise control boundary overlay to properties on the terrace, which Ms Fowler talked to you about this morning as well. And then just in relation to bird scaring devices and frost control fans, there's, I think in the 42A report, there was a recommendation to make some changes and to include specific rules around frost control fans. So in relation to the bird scaring devices, there are just some minor matters raised in submissions, and Mr Hunt has agreed in part with some of that. And in terms of the frost control fans, there's a question there about one of the standards. I don't think there's anything else that's sort of arisen since preparing the summary that I need to alert you to. And unless you particularly want me to, I wasn't going to go through the sort of recommendations that are set out in paragraph 8 in terms of responding to what's been received in evidence. And Mr Hunt is online, obviously, to answer any technical questions.
Just one, I'm going to go to a detail. Your summary 8D, and I just want to be exceedingly clear when I'm going forward. The difference, the disagreement between yourself and Ms Tate in terms of activity status, I just want to be clear, you're talking about the difference between the RDA and non-compliant, is that correct?
Yes, that's correct.
Okay. So my follow-up question is, can you think of any other thing, if a resource consent was applied for, that you would want to consider other than noise, if that standard was breached?
No, I think you're correct that at a broad level it's related to noise. I think if it was obviously for a restricted discretionary activity, you might give a little bit more guidance in the actual detail of the matters of discretion around what's specific things you were talking about, because in that context with the acoustic insulation, it's about considering the noise. I think it's about considering the noise received. It's also considering what is the thing that's being established, and location and orientation type things in terms of how does that mitigate potentially against noise received. What is the context of that as well? So, but yes, I agree with you that there's not a broader. There's nothing else that I can think of that would otherwise need to be considered in the assessment of whether that or the lack of insulation was appropriate in the instance. Yes.
Thank you. Now, I've got, it's going to be probably a difficult question potentially for Mr. Well, it's not difficult, it'll be easy for him, but I'm wanting to gain a bit of an understanding around some of the specific noise control measurements that have been sought by different submitters, and in particular thinking the evidence of Dr. Trevathan for Kiwi Rail and for Waka Kotahi. They all seem to be putting in slightly individual measurement approaches that suit their particular circumstances. And I'm not, what I'm probably seeking is some clarification on a technical side as to what the real differences are and how much do they matter, what the measurement systems are. So it's quite a vague and unspecific question, and I'm just wondering if Mr. Hunt can perhaps help by providing a bit of background or some understanding as to really why does it matter? Is it one or the other? Is it all? Does it matter if the plan has different standards applying to different activities? That's probably the broad understanding I'm seeking, and I'm sorry it's quite an unclear question. Good morning, Mr. Hunt.
I'm able to make comments about that. I think overall it probably doesn't matter. The thing is, it's not a noise emission limit for highway noise or rail noise. They're just providing tools that we use to assess the degree of effects in the corridors affected. I did comment around, the default position for transport noise of all kinds, like port, airport, roads, is to adopt a 24-hour measure of sound exposure, because it equates to daily noise, and we do tolerate higher levels of noise so long as there's quieter periods later on. There are also some refinements. For example, aircraft noise has a 10 decibel penalty applied for night time, but it's getting a bit too detailed. In reality, I don't have any issue because these are not noise emission limits except in relation to the port and the airport, and they are regulated under a national standard which recommends this 24-hour measure of noise exposure, and it's quite acceptable in terms of effects. Kiwi Rail are perhaps the odd one who have determined that affected areas for rail noise should be determined on a 1 hour basis, so the worst 1 hour of noise exposure, which is a little odd, but I take it's being promoted that way because if you did average the amount of noise from the small number of movements that occur over a whole day along a railway line, that it doesn't actually add up to much in terms of total average daily noise. So they promoted the shorter term measurement of noise exposure, which honestly I've struggled with all these years. I can't think of it. And interestingly, when inquiring about, well, how much rail traffic is on the main line that passes through the district, all of the data is provided on the basis of how many movements per day. So obviously day metric for noise exposure is pretty logical, but however we're able to deal with the request, which is based on noise impact assessed on the worst case 1 hour basis. We just have some slight disagreement on how far from the railway line would that area be, and then there's this allied issue of as measured from the track or the rail designation, and that's a small but significant difference in the area affected. So we've looked at that, and we've got a position, and perhaps it's not final, but we do have to watch out for these. I mean, if you look through the list of unresolved matters, most of them are to do with reverse sensitivity, and my job is to make sure that the impositions that are coming through the noise chapter on noise insulation or land use control are based on a rational assessment of the likely future affected areas. And I have found in some cases, I think these noise boundaries are being placed a little bit further from the road or rail corridor than is really warranted, but the matters have largely been resolved, although we do have some differences. For example, highways with posted speed limits greater than 50 kilometres an hour, we've recommended the noise affected area be delineated to 80 metres from the road, and Waka Kotahi would like it to be 100 metres from the road, and so there's slight differences there. But all in all, to answer your question, yes, there are some slight differences. It doesn't really matter. We're not trying to enforce limits on how much noise comes off the road. We just want to know, we use that unit to work out what are the effects alongside the road. And hope that answers the question.
It does, thank you, that's helpful. That's it. Thank you.
I feel like I've got questions all over the place for this, Ms. White, so please bear with me. My question is around the practicality of frost fans, and I've got questions around bird scarers as well. And so in the evidence that is provided, which is on the ground truths around the operations of frost fans and temperatures that vary across land during their use, we still are putting in permitted trying to still not enable it by having frost fans that are only operated when the air at canopy height is 2 degrees or less. So I just wonder, when even with the evidence that was provided to show that the variability of that, we're still sort of pursuing that rule. And I just wondered, even after reading the evidence, we still feel that we need to put restrictions in there on temperatures. And I just wondered if what is the rationale to try and restrict frost fans? Does the Timaru District Council receive lots of complaints around noise of frost fans? I suppose I'm wondering why we're needing to put so many rules around the usage of it. And have we received lots of complaints to put in all these restrictions? I just wonder if there's some background to that.
So I think I might answer the second question, which is around the complaints in the background, and then I might ask Mr Hunt to quickly on the outstanding matter, which is about the limitation to 2 degrees. I think starting off, I guess, by way of background, in the notified provisions, there wasn't a control for frost fans, and actually what that meant was that it was more likely that consent would be triggered under the standard rules applying in the general rural zone because of the nighttime limits that would apply to those activities. So these are noisy activities that operate in the nighttime period because that's what they're there for. And so what's being recommended, I guess, is actually a response to that. We think that you should have a more targeted regime that does actually still manage noise appropriately, but essentially permits these, so you don't necessarily have to come in and get a resource consent, or where you do have to come in and get a resource consent, it's specific to the context of frost control fans rather than this kind of catch-all rule. So I think that probably is some quite important context, because at the moment the council is regulating it effectively more stringently. Although I understand that there is a question around, there's a rule in the operative plan, and this always comes up with a lot of plans about what's normal agricultural noise or not. So, but sort of putting that to one side and assuming that consent is required, it's about having a more targeted regime and saying that's appropriate because it acknowledges when these are used for and the importance of them to agricultural activities. In terms of complaints, I don't know the answer to that. What I do know is that there have been, I think, it was either 4 or 6 consents that have been issued, so not a huge number issued so far. But in my experience with other districts, it is something that can create complaints if not managed. So I have been involved with district plan provisions in other districts where there has been a lack of specific control and issues have arisen with a number of complaints, and then a plan change has been undertaken basically to impose a specific regime. So in this instance, Timaru probably has the advantage that before you have a lot of fans establishing, you're getting probably more of a best practice regime put in place in the plan, so it's not determined on a sort of consent by consent basis. It is a package of provisions. But I'll ask Mr Hunt to comment specifically on the canopy height control.
Thank you. I pointed out in my response to the submission by Hort NZ that I'm not an expert in horticultural measurement of ground temperatures and their effects on plants. To step back a little bit, where the proposed wording came from was a consent order in relation to the Wairau Aotearoa Resource Management Plan in the Marlborough district, and that was actually a plan change because the way in which frost fans were operating was generating a lot of complaints, including operating longer than was considered necessary. And so that rather specific requirement around 2 degrees has come from there. I'm not wedded to it. I think if there was a viable alternative, we could look at it, but the submitter requested a rule that indicated that the machine could operate at 2 degrees above the critical temperature for the crop being protected, and I just felt that was virtually unenforceable, and that we couldn't just abandon the idea that you could switch these things on at any temperature. So after considering the submitter's point, I retained the certainty that I believe council needs to have around 2 degrees at the canopy height, as it seems to function pretty well in other districts, and I found what was asked for was too uncertain. So that's my response.
Can I just add one other thing, which is that this response was in relation to 2 submissions. So it was in relation to the New Zealand Frost Fan submission and the horticultural submission, which were similar but not exactly the same. But it was actually, this standard was actually proposed in the submission of Horticulture New Zealand. So I do have some difficulty, I guess, with putting a submission in that seeks a permitted regime that includes the standard, and then coming back and essentially saying the council's being too harsh with its recommendation and including this standard that we sought that you add. So I think what Mr Hunt has indicated is that there might be another, I guess, way of doing it, but my first, I guess, principle is to say, well, actually you asked for this, so yeah.
I appreciate and understand that too. I suppose because it's new and we're not in Marlborough.
Yeah.
I'm just concerned, I just want to make sure that it is set right for our community that isn't a big user of frost fans. So I'm just trying to make sure that we're not thinking we're going to turn into a Marlborough, because we're not. Okay, that's great. Thank you. That really helps. My other area is bird scarers. Love a good bird scarer where I live, so just noting that. One of my concerns is that it's very restricted, and I feel, on the type of bird scarer, and I'm not sure who this question is actually to, because if I talk about personal experiences in our areas that use bird scarers, we can use rotational scarers. So I'm not sure how this rule will apply to different types of bird scarers, and are we trying to restrict the type of bird scarer in our district? Because at the moment the rule says, that it needs to face away from any sensitivity. But how does that work when you've got rotational scarers? I suppose that's what I'm trying to say, is that I feel like it's restricted to one type and that won't work. So has there been any thought into that?
Yeah, I think that might be a question for Mr Hunt if he can answer it. Yeah.
The matter has been raised. There is an attempt to minimise the harshness of the impulsive sound from bird scarers when they're pointed directly at a sensitive site, even though the noise limit might be complied with. There was submission points on this, and we've gone over it again. What wasn't allowed for was the idea that a portable small screen could be placed in the direction of the sensitive site, so that for either rotational or fixed direction bird scarers, there can be maximum coverage of the bird scaring sound, comply with the upper noise limit, and reduce the direct sound harshness towards sensitive sites. So I believe we've found a way to deal with that. I think anything that we can find that compromise between getting the job done to protect the crop from the birds and minimise the impact on neighbours is where we've tried to land on this. So I think we have a way of dealing with that issue you've raised.
So I think probably the answer to your question, Commissioner Scott, is that the rule probably did lend itself as notified perhaps to preferencing one type of machine over the other in response initially to submissions, but then in terms of having reviewed the evidence, I think where Mr Hunt and I are sitting is to recommend something that, and he explained it there about having a portable screen to address that issue of the harshness of the sound, which would allow you to use a rotational device and still achieve or mitigate the issue of the harshness of the sound where you've got rotational bird scaring device.
Follow that, because my concern is that if we're receiving lots of complaints in our district on these, is it in a particular area that is of complaint? So, for example, is it in the airport area? Is it, so we're putting a blanketed approach across, and where it could be cropping, so bird scare is used in multiple different types of ways, and I wondered whether we're trying to put a blanketed rule across something and we're only receiving complaints from one particular area within the district, because I understand we do receive complaints with regards to the airport, and if we're trying to fix that problem, I wonder whether it's going a bit far.
Yeah, so I can find out for you and report back in terms of the number of complaints and where they're received from. I think the other contextual piece is probably that there is a rule in the existing operative plan, and this is essentially a review of that to try and make it better. The current rule doesn't have this sort of direction away requirement, but it does have a standard that talks about located as far as practicable away from adjoining residents and shall be aligned to point away from adjoining residences. So this is, sorry, I think I said it didn't have that. It does. It says they should be aligned to point away. So this is actually an improvement on that in the sense of that rule as it currently stands says in all circumstances you have to point away. And I think in response to the submitters and the evidence saying that doesn't work, it's not very practicable, we're trying to find a pathway to still mitigate the noise but address that. So the recommendation, so what I'm getting at is that the rule is notified as the same as the current rule, and what we're recommending now is more permissive than that to try and address the concerns that have been raised in submissions, but it's not placing a more onerous requirement on bird scaring devices than is currently the case. But I will find out about the complaints.
Okay, I think we'll just take our morning tea break now for 15 minutes. We've still got questions on this topic, Ms White, and sorry, Mr Hunt, we need to keep you online a little bit longer. So we'll adjourn for 15 minutes. Thank you. Thank you. Commissioner Solomon, questions?
So I think that I'm not sure either. So I've gone back to the Section 32 report and not been able to find it. I've gone back to a sort of a background lighting report that was done to try and understand if it came from that. But ultimately, it wasn't clear to me. There was some discussion in there about the potential to have controls essentially for sort of, I think it's referred to as intrinsically dark landscapes. So essentially where you have areas that are already dark and there is value in that darkness and therefore having controls to minimise lighting. But I couldn't find any indication of how that had translated, if that was what the light sensitive areas was the genesis of. And certainly I couldn't find any analysis as to how, if that was the case, how that had translated through to the specific areas. And as you would have seen in my report, I think my biggest concern was that if you just pick up other overlays in the plan which have been developed for a very different reason, I don't think it follows that because you've identified something as an outstanding natural landscape, for example, that you therefore need to protect it from a lighting perspective. So that was the difficulty essentially that I had in not being able to find a justification for why those areas had been selected, but also what those provisions were trying to achieve and whether that was justified. And in looking essentially at what was sought for each of those overlay areas, I couldn't really find anything to hang my hat on, with the exception of the request from DOC to add the bat protection overlay where that is related to essentially the protection of significant fauna.
Through to 300 metres. Was that measurement based on a technical report?
Sorry, could you just give me the paragraph reference again?
Paragraph 8.2.6.
Okay. So is your question to do with the 1 to 300 metres and then the 100 metre?
Well, it is, but I really want to know, were those measurements based on a technical report? Where did those measurements come from?
So yes, they've come from Mr. Hunt, and so they're in the appendix to my Section 42A report that has his recommendations.
Right.
But essentially, I think that the distinction, I guess, that's made there is that the within 100 metres, the requirement is essentially to apply a requirement to acoustically insulate to a particular level within proximity of a frost control fan. So Mr. Hunt's advice around at what distance would you need to start doing that was essentially 300 metres, and then the distinction between, I guess, within 100 metres is to do with the fact that while you could acoustically insulate, you'd need to, you couldn't just pick up one of the standards that we already had in the proposed plan and apply it. You'd need something further than that. And in absence of a more stringent standard basically being in the PDP, it made more sense from my perspective to have a consent requirement where you specifically look at that acoustic insulation and say, is what is proposed here sufficient?
Okay, that makes sense, thank you. On another noise matter, but this time it's 20 The Terrace. To clarify for the map the 20th terrace is not included in the noise control boundary, the port noise control boundary, I mean, the outer boundary, as I understand it. I've looked at the map and the noise control boundary goes around property. I could see that that property has a car park facing the port, and I presume the buildings behind are not sleeping areas. Are these the reasons for not including the property within the overlay?
I might pass that question to Mr Hunt, but I mean, my understanding is that the modelling was done based on kind of best practice of modelling, and there's a methodology used, and that was undertaken by the port because they'd requested this, and then reviewed by Mr Hunt. But my understanding is that it's been done essentially in line with best practice. But I might ask Mr Hunt if the existing land use comes into play. I think that's probably the question, is does the existing land use come into play when you're making the assessment of where the noise control boundary goes, or does it not?
Thank you. The expert on behalf of Port Company will be able to answer this more precisely, but my understanding is that land contours have been included in the modelling, but screening by buildings, I don't believe so, and that's because the building may be modified or removed during the life of the plan, and that would need more exposure than perhaps the contour forecast. I would point out the rule for insulation does allow for an expert to prepare a report to prove or to show that the port noise levels at a particular location would be below a stated threshold in the rule, which would avoid the need for acoustic insulation. So the rule does allow for site-specific circumstances to be considered, and report would need to be produced to satisfy that requirements of the what we call the exemption rule, and it would be a way of handling.
Who could answer that question for me?
So I think that's probably the noise expert for the Prime Port,
Okay,
Mr
I'll
Trevathan.
ask
I think,
that
yeah.
question. Thank
I can
you.
understand your question because
Yeah.
looking at the map, I can see why you've asked.
Because my follow-up question is, should the property convert to residential use within the life of the proposed plan, would the new residence need to be built with acoustics insulation?
So I can answer that one, which is if they're not in the mapped area, then no, they wouldn't, because obviously the requirements only apply to the ones within the mapped area.
Right, okay. In your paragraph 8.17.6, if Timaru has a similar climate to Christchurch, I find it challenging to accept that windows will be only open for limited periods. So my question is, what is meant by limited periods?
So in this context, it's really, I guess, a cost-benefit question. So the submitter has asked essentially that in relation to the ventilation requirement, so when you are required to acoustically insulate to the specific level, that there's also a ventilation requirement. And they have said that should also include a cooling function basically for when temperatures are above that level. So there's obviously a cost associated with that type of ventilation system. And so the limited periods, I guess, is for the times of year where from a climatic position you get to that level, is the 5 or 6 times per year that it might be, for example, at that level where you might need that cooling function, is that sufficient to justify basically the additional cost? So Mr Hunt has commented on that as well, and I think where he got to was that he was fairly neutral because of the climate and that it wouldn't be needed all that frequently, and therefore wasn't convinced that it justified the additional cost, but he was relatively neutral on it. And I think the submitters come back in evidence and said that they still want to pursue that. But that is, I think, the key question is for the amount of time that you would need to basically rely on that function, does that justify the cost? So I do think that is the key issue.
Thank you. Thanks.
Thank you. Ms White, I have some questions for you just on the issue of reverse sensitivity, and they're probably general questions applying to a range of situations under the district plan, particularly in relation to noise. I just wanted to interrogate really what you mean when you refer to reverse sensitivity, and whether or not it includes effects on the health of occupants of activities, or whether the effects on health is something different to reverse sensitivity, just in your own planning understanding of those terms.
So I think in my mind they are different. So, but in saying that, I think the latter, so the effects on health of occupants, I think could potentially play into when a reverse sensitivity effect might arise. But I do think that there's still, that the health on occupants is still a separate matter as well. So to my mind, reverse sensitivity is where you have an established activity, or in some cases in this district plan, it's not necessarily activities that have established, but it's activities that are anticipated in a zone, for example, that have a level of noise associated, so a legitimately established level of noise associated with them, that might create a conflict with a noise-sensitive activity, and the effects arise. So there's the actual noise effect, but the reverse sensitivity effect is essentially where the more recently established noise-sensitive activity, as a result of those noise effects, then complains about the original activity, but to the point where the complaints result in the original activity having to modify its operations in some way to essentially address that conflict. So the reverse sensitivity effect is not the original noise effect, which is where that effect on the health and amenity of occupants might also arise, but is then how that original activity has to respond to the establishment of the noise-sensitive activity.
So in terms of evaluating in a Section 32 and relative risks, provisions which are being advanced in the district plan and the language used by even Mr Hunt around reverse sensitivity for noise, do we need to first establish that there's likely to be an adverse risk to health? And then do we need to consider whether that might result in a risk of complaints? And then do we need to consider whether or not that is likely to result in constraints on that existing or anticipated established activity?
So I caught the first bit of that. Could you repeat there was the question is, does there need to be an adverse risk to health?
Yes, and then does there need to be, or do we need evidence of a risk of complaints? And then whether we need evidence as to the likelihood or the risk that might result in constraints on the established activity. Or can we go straight to complaints and constraints if we're talking about reverse sensitivity?
So I don't think that in terms of that first question, does there need to be an adverse risk to health? I don't think it's limited to that. I think it's particularly with there's obviously the very extreme example where the effects of noise do have that impact on health, but I think there's also amenity effects. So there's the nuisance effect associated with noise, which I think is lesser than when you get to the point that it's impacting your health, appreciating that those are also interrelated.
Yeah.
But I don't think it has to be an adverse risk to health. I think obviously if there is an adverse risk to health, then you probably tick that box, but I think it can be a lesser standard than that. In terms of your question around does there need to be evidence for a risk of complaints, it's very hard because until you have, you don't have complaints until you get complaints. So I think in this instance, I think where the controls are being proposed, it's in instances where that type of thing has arisen in other areas for similar activities. And so so there is some evidence, I guess, in a broader sense, about the likelihood for complaints to arise because that has happened elsewhere, and the provisions are, in essence, a response to that risk. And again, with the evidence as to the likelihood of complaints, I think, again, it's reliant on what's kind of happened elsewhere and the framework that's been put in place. So I think I can't think of any provisions, reverse sensitivity provisions in the noise chapter that are not or don't relate to controls that are applied elsewhere. So there's obviously the rail, proximity to rail provisions, proximity to the state highway provisions, the port is obviously, there's less ports, but I am aware that there are noise control boundaries associated with ports. The airport, the raceway is also in the operative plan, but I think there is noise control boundaries in Christchurch and in another district I can't think of for that. And the other controls are within zone, and that just reflects, again, that's not uncommon to say where you have a zone where a range or mixed-use activities are anticipated and the permitted noise level is higher than would be appropriate for noise-sensitive activities in absence of that installation. I think that's pretty common. So I think the evidence around that is kind of reliant on best practice and what's happened in other areas as well.
Just on the issue of rail, the plan as notified included the 40-metre distance as the trigger level for installation requirements, and Kiwi Rail are seeking that to be extended to 100 metres. What's the evidential basis for the 40 metres as a starting point? And if you need Mr. Hunt to step in, that's fine.
Yeah, I think that probably is a question for Mr. Hunt.
Yes. The evidence is attached to the expert evidence from Dr. Stephen Charles on behalf of Kiwi Rail, who's presented measurements of rail noise at different places, admittedly not in the Timaru district, but it does refer to elevated noise within certain proximity to the rail line, and the 40 metres has that origin. There were earlier reports that I authored to assist Council in developing the noise chapter, which stage 1 report particularly looked at potential impacts, including health and reverse sensitivity effects of transportation noise in the district. And that was further developed into stage 2 report published in 2018, which specifically looked at each of the sources of transportation noise and the relevant standards, and suggested a course of preparing some rules around an adequate level of protection. And for rail, we've come up with this 40 metres, and any indications why it needs to be more than 40 metres should be addressed to Kiwi Rail's witnesses, because, you know, we're just trying to get the right answer here in a balanced compromise, I guess you could say, whereas the submitter would just rather that new and altered dwellings incurred these costs way out to 100 metres, because it doesn't affect Kiwi Rail's operations and it allows them a measure of comfort, I suppose. So, yeah, it's really about setting a balance, and based on noise effects for rail, the 40 metres seems as reasonable. And there is that issue we alluded to earlier, that we are assessing this on the worst case noise for 1 hour per day, and there has to be some questions raised about that, which I had raised.
Thank you, and I'll go back and read those earlier reports from 2018, but is there any reference there to, or are you aware of any studies that might differentiate between the effects of rail noise versus road traffic noise versus ports, airports and the like?
Yeah, well, generally, when transportation noise is assessed uniformly on an average 24-hour noise level, and comparing the annoyance reaction to aircraft, road traffic and rail, I'll just have to park port noise for a moment because that's very site-specific in its effects. But regarding those other transportation noise sources, that generally aircraft noise is more annoying than road traffic noise, which is more annoying than rail noise when all received at the same level. So this is the sort of results from community annoyance surveys and the like. So there are sort of slight refinements, and for example, aircraft noise, because of its sleep disturbance impacts, if it occurs at night, then there's a 10 decibel penalty at night for those noise events. And these are the sort of finer elements that are set out in the relevant New Zealand standards that have been adopted into the proposed plan. So I'm not sure that answers all of your question.
I suppose at a general level, yes, the answer is yes, there are differences. In terms of, are those differences directly related to health and amenity effects? Like, are there differences in the way that people receive or react to noise from different sources?
Well, there are. It's getting a little specific, but aircraft is very event-based, and so annoyance and sleep disturbance are common. Traffic noise is more of a constant type sound, although you can experience sleep disturbance during the nighttime hours for the loud individual events, but the sort of science around it is that the average sound level over the whole day is adequate to predict whether that will be a satisfactory noise environment for sensitive users. Port noise, I didn't, it's very site specific and it really is event based. I think the general hub of a port is quite widely accepted in the community, but it'll be the impact sounds and during night time which tend to cause complaints and awakenings, and there are some nighttime specific LMAX limits which are designed to sort of manage that outside of the port noise boundaries, so that inside the boundaries there can be an expected level of effect, which is what's driving the mitigation in terms of insulation and ventilation for new or altered habitable rooms. So But yeah, there is sort of subtle differences, but at the same time, the generic approaches around identifying affected areas, promoting reasonably effective mitigation measures. There's some disagreement around some of the finer points of ventilation and that, but these are the sort of appropriate measures that I recommend, and they're consistent with what's applied in other districts. And of course, people like Kiwi Rail and Waka Kotahi are very keen to ensure the Timaru plan has similar requirements to other district plans. As a network operator, they're concerned about reverse sensitivity effects, I guess, across the whole country.
Thank you. In some areas of Timaru, particularly in the urban area, there will be locations where properties are subject to noise from a combination of sources, port, rail and road. Is there any different approach that should be taken in those contexts, or is it simply just to layer each one and let the potential consent holder sort out which acoustic source or which noise source they should be most concerned with?
Well, that raises an interesting point, but basically the way the acoustic insulation rule works, we've been very keen to ensure that the standard applied for new apartments in the CBD is a similar standard to the moderate noise affected area around the airport and so there is a measure of consistency that's designed for council officers in particular to make rather straightforward assessments about which mitigation measures should apply, and that contrasts with the submissions by Waka Kotahi and Kiwi Rail, which seeks to design the insulation around a measured nominated indoor sound level from that source, rail or road traffic. And that does lead to all sorts of conflicts in the situations where one may overlay the other. And so I feel that the proposed plan is well placed to deal with that multitude of effects. But yeah, I mean, it's a fact. Cumulative effects that do need to be examined, but I think the measures, there's a good consistency around that insulation requirement. That means that it's going to be effectively dealt with, even though it is a cumulative situation, and that has leaves the council better placed than these specific proposed insulation rules that are based on an internal sound level, which can lead to conflicts, and then the choices what would be the target noise level to design to, and questions like you've raised.
I think if I could just add to that, Madam Chair, what Mr Hunt, I think, has pointed out is that what's been proposed in the plan is a fairly standard approach, which applies, it says acoustic insulation is required in these areas, and then in standard S3, there's two different levels, so which Mr Hunt refers to, I think, as moderate and advanced. So it's, if you're in more than one overlay, it's actually going to be quite easy still to tell which requirement you have to meet. And where you're in two, because there's two splits, obviously, where you're in more than one overlay and they're in both, then you'd obviously have to meet the advanced level, essentially. And I think the point that Mr Hunt raises is that from an efficiency perspective, that works quite well if you were to accept some of the changes sought by the submitters, which are specific to some of those areas. Then you might have less of an efficiency because you'd have a rule that might be slightly different with respect to being in the road noise, in the proximate to road noise, that might be different from what is then required because you were in the city centre zone, for example. So what is proposed, I think, seeks to make that much clearer, and then not to have a thing of saying, well, if we have to do this for road noise, but we have to do this other thing, which one do we follow? So I think we have avoided that in what we've recommended.
Thank you for that. And thank you, Mr Hunt, for those explanations. Ms White, I also just had a question around the definition, the noise-sensitive activity definition and the reference to papakainga and marae, or marae activities, I think, as one, as Kiwi Rail. I think in our last hearing we received evidence from the Ngāi Tahu planning witness, who's Ms Pullen, and she was suggesting that activities such based on marae and papakainga shouldn't form part of that definition, or there should be some regulatory relief, I guess, for those activities, given that they're reasonably fixed in their location and have coexisted, for example, with rail for a long time. Did you have a view on that in response to the issues that she'd raised, and particularly in relation to the fact that Kiwi Rail are also seeking amendment to that definition?
So I haven't considered that, in that I've focused on the submissions that were related, I guess, were allocated to this topic. So I haven't turned my mind to that particular matter that she raised. So I'd need to relook at that evidence.
I think, just for continuity, if you could perhaps do that, you can do that as part of your interim reply. That would be helpful for us. No, I think that's all I have for you at the moment, and thank you to Mr Hunt as well. We'll move to the next reporting officer. Thank you.
Thank you, Madam Chair. I now have Mr McLennan sitting with me, and I will ask him to present his summary.
Kia ora. Yes, I'm the reporting officer for public access, activities on the surface of water and versatile soils. And I've provided you with a summary statement. And like the other reporting officers, I might just try and highlight the bits that are still, the parts of these reports that are still have issues, rather than just within the submissions, but more within the evidence. And I guess starting with the public access chapter, in paragraph 3, I've listed a few of the issues that were raised in submissions, but in paragraph 4, note that all of these issues raised in submission appear to be resolved within the evidence, and that's supported by evidence from Transpower, Primeport, ECAN and DOC. At paragraph 5, I start on the activities on the surface of water chapter, and again list the issues that were raised in submissions. Paragraph 6, I note the following issues are still outstanding. So Ms Francis for ECAN seeks that the objective to this chapter ensure that the district's rivers are protected from inappropriate adverse effects of activities. Ms Williams for DOC seeks a number of amendments to the provisions within the chapter. Firstly, the addition of a non-commercial within policy 3, and in my notes of on my corrections, sorry, I've noted that's an error that will be fixed within my interim reply. She also seeks amendments to the temporal restrictions within rules 4, 5 and 6 of the chapter to align with the evidence of Mr LaGrue for DOC, which suggests that the recreational use of motorised craft should be undertaken between February and July to avoid the bird breeding season. Ms Williams also raises 2 anomalies with Rule 3. Above red rocks, the rule includes 2 clauses that essentially are protecting fish spawning activities, being a time limit and a mapping overlay, and that there's no temporal restrictions on the Rangiatāta River to prevent recreational use within the bird breeding season. And so she seeks amendments to that rule to include a temporal restriction over the bird breeding season, or suggests that the rule should be reconsidered as part of a comprehensive review with stakeholders' involvement and also involvement from the Ashburton District Council, which is the boundary that the two districts share. In paragraph 7, I've noted my view that I was questioning the scope of that suggested change. Since then, there's been some legal advice on that from DOC, and Ms. Vella's also sort of raised that. So I think maybe I could proceed on the basis that I can help discuss the merits of that rather than the scope, and then that scope issue can sort of be left live. And if you'd like, I could sort of make some comments on the merits now, or I'm sure there'll be a question, if not, as to my view on those suggested changes to that rule.
That was one of my questions, so happy for you to just do that now. If you want to.
Sure.
Thanks.
So I guess the concern on the merits I have with the rule is that it is currently notified and recommended, it aligns with the Ashburton District Plan, and so there's certain times of the year where you can jet boat above Red Rocks, and there's certain times when you can't jet boat, and they align. And so the concern I have is that if you were to make it an inconsistent time, 9 months of the year you could jet boat on the Ashburton side of the river, and then the other 6 months, which also align, you could jet boat on the Ashburton side of the river. And so from a enforcement perspective, it would be pretty tricky to say, well, I saw you on this side of the river, not that side of the river. And from an effects perspective, I think you would still be scaring the birds, whichever, potentially, and maybe DOC can provide a little bit more assistance on that or not. But it just seemed to create kind of an inconsistent approach that would be tricky to monitor and enforce. And although it's not perfect because it doesn't protect the bird breeding season, at least it's consistent across that river. And so it's kind of, I guess, the lesser of two problems. And so I think where Ms. Williams got to in terms of having a comprehensive approach to undertaking that cross-boundary comprehensive approach is probably a better approach, and in the meantime having a consistent approach is better than having an inconsistent approach. So that's kind of the view I have for that rule.
Have you made any inquiries of the Ashburton District or sought to understand what the evidential basis is for their rule?
Yeah, Ms. Williams actually provided some of that within her evidence as well, and it was an alignment with the operative Timaru District Plan that they were seeking to, as well as evidence that it was an important salmon spawning site. So there was no real justification in the plan change that introduced the Ashburton rule that suggested that bird breeding was something that was going to be considered. It was largely a salmon spawning control, and a control that also aligned cross-boundary with the operative Timaru plan. So she makes the point that if we keep trying to align with an area that doesn't include bird breeding, then we never get to the point of having something that works for that protection, and that's a valid point.
Well, that is a valid point. If there's evidence before us, and if we're satisfied on the evidence that there is a risk for bird breeding, we should not address it, should we?
No, I guess the thing that I'm raising is that even if you knew that that was an effect, the concern with the implementation of the rule is that you could boat down the other side of the river, for want of a better term, and still have that effect. So I think the effect is valid. It's the question of how the inability to manage the other half of the river is the point that the application of the rule would still be the problem. And just after paragraph 7, I note that on the activities on the surface of water topic, evidence has also been provided by Jetboat NZ, which is not included within the summary because it came in a couple of days ago. But I've read through that evidence, and generally I note that the positions between DOC and Jetboat NZ have narrowed considerably as part of that evidence exchange. So the objectives and policies are largely accepted by both parties, and the difference remains in the temporal restriction across rules 4, 5 and 6, with Jet Boat NZ seeking different temporal restrictions to what DOC has been seeking. And the other thing is that there's 3 additional rivers still being sought by Jet Boat NZ to be included within the permitted rule framework. And I haven't got a complete view on those 3 rivers yet, but that's, I guess those are, I'm highlighting the fact that the positions have narrowed considerably from submissions to evidence. In terms of the versatile soils chapter, the main issue was aligning with the MPS HPL, and I note that these issues raised in the submissions appear to be resolved in the evidence. There wasn't anything within the evidence that was seeking amendments to that chapter, so yeah, that's, I guess, all I have for that one. And then within paragraphs 10 to 17, I've listed corrections to my report. The first one relates to the description of the rural areas, and there were some amendments in hearing A that I didn't pick up in my hearing F report, so I'll pick those up within the interim reply. As noted, Ms Williams has picked up there was a missing non with a non-commercial recreation. And then the next 5 paragraphs relate to some mapping. And so Schedule 13 of the PDP includes some mapping protecting fish spawning areas. And within these paragraphs, I note that these mapped areas align with the Plan Change 7 mapping to the LWRP as notified, and since notification and through the hearing process, that mapping has changed. And so the suggested amendments that I've included within Appendix B relate to changes that align with the now operative PC7 LWRP mapping as opposed to the notified LWRP mapping. And there are little things in there like the mapping goes beyond the district boundaries and a few other bits and pieces, so it's a bit of a tidy up of what's there. But just for completeness, I know that there's no amendments to the Schedule 13 drafting. It's mapping changes rather than changes to that schedule. So that's pretty much all I had as a summary. Happy to take questions.
Thank you. I've just got one question, and it's around objective ASW1. And it's in relation to Ms Francis's evidence, her last paragraph. I'd like to get your view on what different evaluation might occur under either her wording or yours. And it's paragraph 62 of her evidence, I think, is where it is.
So in her wording, the adverse or the inappropriate adverse bit relates to an effect, yes, as opposed to, in my wording, the inappropriate part relates to an activity.
Yes. So don't get me wrong, I understand the rationale
yes,
of why you
sure, yeah.
I'm just curious from a planning perspective, what kind of what kind of different evaluation or different things does that, the different wording, does it lead you somewhere different, or so it's a more general planning purpose as opposed to rationale?
Yeah, it's a good question. Not something I'd turned my mind to necessarily. I guess the drafting I had adopted was seeking to essentially align with Section 6A of the RMA in terms of it being the inappropriateness of the activity. I guess Ms Francis's wording means that there could be, for example, because we're talking about jet boating or other activities potentially, Yeah, I'm not exactly sure, to be honest.
Yep.
You could have it, I guess it's saying that there could be an activity that could be appropriate or couldn't be appropriate depending on the effects that it generates. But I'd have to think, maybe that's something for a reply, because I'm not sure if I'm answering that question very well for
That's
you.
right. That's fine. I've got a couple of questions for Ms Francis, so perhaps the questions I pose to her might help in your reply. Thank you. That's all.
I have questions around activities on surface water, but I will direct those to Doc and Jet Boating New Zealand, just for clarification. But I just want to understand on versatile soil and removing the versatile soil overlay, and obviously it's noted in here that that will make it larger, which will increase the cost to landowners. But my question is just for understanding purposes too. So what you're saying though is once the RPS has been done, the mapping then would do a variation, because then that would, okay. So what, how long do you reckon that would capture that for though? Like, so I know we have no idea when the RPS is going to be done, but is there a risk that it will affect more people in that time frame? Like, I'm just concerned that making it larger will have quite a large impact.
Yeah, there's
the economic cost will be quite large.
Yeah, I guess there's a couple of things to note. So I guess the first thing is that the PDP mapping only includes the class 1 and 2 soils in terms of what's defined as versatile soils, but that the NPS HPL defines highly valued land or highly productive land as 1, 2 and 3. And so already if you were to apply a subdivision consent or for a land use consent or if there was a land use activity that triggered resource consent, the NPS HPL 1, 2 and 3 categories already apply. So that's already in place at the moment. And so it's not including an additional layer on top of what's already there, except for the fact that there are 2 rules in the versatile soils chapter, one related to the size of a building and the other related to subdivision of versatile soils. So it's okay, well, that would already require consent. So it's that one rule, VSR1, which would apply more broadly than in the proposed plan with the proposed recommended definition than would otherwise apply. It's also, I guess, worth noting that it appears central government will be changing the definition of highly productive land to only relate to class 1 and 2 soils as well. And I guess the intention of the drafting is to try and future-proof the PDP by relying on the definition in the NPS HPL. So if it changes, the NPS, the district plan definition changes as well without needing to change. So I understand the question, but it already sort of applies.
Yes, Mr McLennan, in your paragraph 8.2.5, given the provisions are about activities on the surface of water, what should it matter if it's a river, a pond, a man-made lake or an irrigation lake?
Sorry, say the question again.
Given the provisions are about activities on the surface of water, what should it matter if it's a river, a pond, a man-made lake, or even an irrigation pond? Just because my follow-up question is, does Lake Opuha have activities on the surface of its water?
good question. I guess the rules and objectives and policies all relate to activities on the surface of water. And then, sorry, no, because they're talking about protecting district rivers. I imagine that there could be activities on those different things. The focus of this is on protecting the values of the district's rivers, which is why I sought to retain rivers within there.
So should it be called activities on the surface of Timaru rivers?
It could be, yeah. That's what the objective seeks to protect. And there are no lakes in the district, so it is about protecting rivers.
Is Lake Puha in the Timaru district? No, it's probably, is that in the Mackenzie? But there would be big irrigation ponds, and I know that in North Canterbury they do activities on the surface of their irrigation ponds.
Yeah, I guess that's. I hadn't turned my mind to whether these jet boating or other activities should be restricted to irrigation ponds or not. I guess the values that are trying to be protected are focused on rivers, and so to incorporate these rules, whether it's when you can or can't.
So do you think that it's right to just focus on rivers?
Yes, I think so, because otherwise there is only specific activities that you... So there's a catch-all rule that basically says that if you're not one of these permitted activities, you're discretionary. And so if this chapter applied to all water bodies, that may prevent people from taking their boat on their irrigation lake or require consent to do so. And that's not the intention of the chapter. The intention of the chapter is to manage activities on rivers and provide permitted standards for when that's okay and then require consent for when it's not. But it hasn't sought to restrict activities on irrigation lakes in the same way.
So hang on, which one is it? In one of the policies, it talks about, policy 6, talks about activities on the surface of a river, and yet the policy is about activities on the surface of water. Would that not be confusing for plan readers? In your bullet point 4, it talks about activities on the surface of a river.
So this is activities on the surface of water policy 6, subsection 4, is that right?
Yes.
So it's talking about the surface of the river, and which is, I'm not sure, I'm sorry understanding the question. So this does relate to just the river, which is what I'm suggesting that the chapter should relate to. I'm not sure if I'm missing something.
Yeah, no. So I thought you said before that the focus is on rivers.
Mm-hmm.
So I'm just asking, would that confuse plan readers saying, you know, the whole chapter is about activities on the surface of water, and yet that provision talks about activities on the surface of a river? So I'm just asking, will that confuse plan readers?
I think you're right, it may. I would like to maybe just check as well whether the title of the chapter may be related to the planning standards, and so there may be a requirement to call the chapter activities on the surface of water, even though the chapter is actually only intending to apply to activities on the surface of rivers. So yes, I think you're right, it probably is confusing, but I think the reason why it would be labelled that way is because of a planning standards requirement, rather than seeking to manage activities on the surface of all water.
I think it might be useful just to do a bit of a If the headings, there has to be the heading, that's fine, but just throughout the chapter, there seems to be various references to river or water. Just a bit of a consistency check. For example, policy 6, 3 and 4 use the terms differently.
Oh, yes, and then the other thing, sorry, Mr McLennan, I've got one more question, apologies, and I'm not sure if I'm right here, but the Jet Boat New Zealand considers that it's necessary to limit recreational jet boating activities to specific times of the year. If a minimum water flow criteria is adopted, the submitter considers this will have a practical effect of only enabling recreational jet boating in higher flow conditions. But my question is it good practice to make a recommendation on a decision, on a minimum flow decision that hasn't been made yet? I'm not sure if I've explained that properly.
I'm scratching my head a little bit. I guess, so as I understand the Jet Boat NZ submission, they're seeking that we list minimum flow as a permitted standard, and then if you meet that permitted standard for the flow, you're allowed to drive your jet boat up and down it. So it's about how much water's in the river. We can drive, if there's enough water in the river, we can drive a jet boat up and down. And they think that that is a proxy for, if there's that much river coming down the river, the birds are probably already either washed away or not going to be affected by the jet boats. So that's, I understand, the rationale for why they were seeking a limit.
So did you recommend that submission to be accepted, if I understood that right?
So I've recommended that there is a flow rate for when retaining the flow rate that is already in there, while also retaining the temporal restriction of not being able to go up and down the river in bird breeding seasons. I've recommended retaining both.
Okay.
They're seeking to remove the temporal restriction and just rely on the flow rate.
Okay, no, I understand. Thank you.
I don't have any additional questions for you, Ms McLennan. Thank you very much for your evidence and summary.
Thank you, Madam Chair. Our final Section 42A officer is Ms Williams.
Good afternoon. I'm Rachel. I work at the Timaru District Council as I was the Section 42A officer for the earthworks, relocated buildings and shipping containers, signs and temporary activities chapters. And similar to my other Section 42A officers, I will just briefly go over the outstanding issues that appear to remain in evidence. So those appear to be Earthworks Rule 1 and the earthworks exclusions, most notably exclusions C, E and H, and the relationship between the earthworks chapter and the EI and transport chapter. And I just wanted to flag there that I'm still working on the relationship, or grappling with the relationship between the earthworks chapter and the EI and trans chapter myself. And I wanted to clarify that in my interim reply, that I would clarify which rules in those chapters would be excluded by that rule, and what, if any additional matters of discretion were needed to be added to the EI and trans chapters to manage earthworks effects, considering Mr Willis's recommendation to exclude artist activities as well. And then the other matters that were raised in evidence was the traffic safety standards in the signs chapter, and most notably the minimum separation distances between signs, including my consequential recommended amendment to sign standard 6.1, and then the standards managing illuminated, moving, flashing and digital signs, most notably the minimum dwell time, where I recommended it be reduced from 30 seconds to 10 seconds, and the minimum separation distances from intersections for digital signs, and the resource consent trigger for digital signs on state highways. And I just wanted to note there that I wanted to clarify there that a lot of those assumptions were based on the assumption that most digital billboards are likely to be an off-site sign, and are likely to advertise products that do not occur on the site. They may be on site as well, but it was assumed that most of them would be captured by the off-site sign rules and sign standard 4, so would be automatically going through a resource consent pathway under sign rule 4 in addition to the sign standard 2 rules. And then another issue that was raised in evidence was the management of temporary military training activities that was raised by the New Zealand Defence Force. But those were kind of the main key issues that I wanted to raise with the panel.
I have some questions of detail that will wait for the end of the hearing rather than now.
Okay.
Thanks.
Mine is around freedom camping bylaw. So in your 42A report, page 86, it talks about 12.2.6, that the council does not have a freedom camping bylaw in place. Now, we know that we currently do have a bylaw out for consultation. And that's due back. It's currently it's out for consultation and it will come back in on the 6th of May. So my question is, sorry, I'm getting there. So if the freedom camping is not managed by the district plan and is managed by the Freedom Camping Act 2011, what happens when the freedom camping bylaw does come into effect? So how's that going to be managed? Because obviously the council is going through that right now of putting in a bylaw.
Yes, so it's my understanding under the Freedom Camping Act that a council can implement a freedom camping bylaw, and in that bylaw you could determine locations where you think freedom camping is appropriate, or you can set timeframes on how long people can freedom camp for and things like that, is my understanding. And it's my knowledge that that would be separate from the district plan process, and those rules would apply to the freedom camping bylaw and wouldn't be managed by the district plan.
Okay, yeah.
Yeah.
Okay. I just sort of thought we needed to be aware of it because it's a process that's going on at the moment. Fascinating about signs. I learnt so much about signs in our district, so just thought I'd put that out there. And obviously I was really intrigued by the evidence from Fonterra and the port, where they're quite upset, obviously, about signs. And we went from having sort of no limit to then obviously putting limits in place. So my question is there an issue with signs right now? Because obviously they're all in place and we're trying to restrict it right down now to one sign. And that one hand Fonterra is saying, well, we need one sign per vehicle access, and then the port saying that wouldn't work for us. So I was just wondering why have we got to here, and is there an issue on having to limit this? I suppose I'm trying to educate myself on what is the actual issue we're trying to solve.
I think the issue, from my understanding of the Section 32 report, and it was relatively light in this regard, but my understanding is at present there's no controls on the number of signs in the operative district plan, and there's very minimal standards that apply so that signs were able to be established throughout the district, and particularly in the commercial and business type zones and the industrial zone. And then as part of the proposed district plan, they've introduced a no limit in some zones, but then on the other hand, they've also introduced a minimum separation distance between signs. So the no limit to me actually doesn't work in practice, because you've still got to apply for the minimum separation distance. So there is a limit on the number of signs you have on any particular site, because you've got to comply with that road frontage. And I suppose that's what I was trying to address by deleting the minimum separation distances, but then I did think having no limit is probably not appropriate, because then you could establish as many signs in principle as you like on your site. And I do think that wouldn't necessarily achieve the objectives and policies about avoiding visual clutter and minimising distraction and things like that.
Because I live here and I drive around a lot, I've become aware of signs. And I was thinking, yeah, I just didn't think we were overdone with signs, but yeah, I can see their concerns that all of a sudden, you know, what does that mean for them, and what restrictions does that mean to them now? And I didn't, you know, I was down the port the other day and I didn't think it was congested.
Well, I similarly have been obsessed with signs now, and when I drive around I've been looking at signs, and I have to admit I don't see a huge issue at present with the signs that we have, but I'm not an expert in terms of visual clutter and traffic safety.
Sticking with signs, Ms Willocks.
Yeah.
What are the potential adverse effects caused by high dwell times?
That would be more a question for probably Logan and Jeanette, who I believe are online. But I suppose the higher...
I didn't get it, but I know what it is.
Yeah.
But I want to know what the adverse effects would be from that.
I suppose the key issue is if you've got a lower dwell time, it's more likely to flash a different image, so then it could be more distracting from a traffic safety perspective, is my understanding. But I'll get Logan and Jeanette to potentially elaborate on that.
Okay.
Yeah, so the issue of... Oh, got a bit of feedback. The issue of dwell time is the shorter the dwell time, the more exposure there will be to a greater number of drivers. So generally speaking, the longer the dwell time, the less exposure there is, and the change in the way when the sign changes its image, that is a source of distraction. So the more often the sign is changing, the more distracting it will be, and the more drivers will be subject to an image change.
Okay, thank you. I understand. So, sorry, back to Ms Willocks. In your paragraph 11.6.13, it says the Christchurch City District Plan, for example, only restricts signs located adjacent to a state highway or arterial road where the speed limit is 60 kilometres more. 70 kilometres or more. Is Christchurch an appropriate comparison to use for locating signs within a 50 metres of a highway with a speed limit of 70 k's or more, given that Christchurch is a bigger city?
I suppose that was raised in the evidence of NZTA, that they didn't think it was a relative comparison because it's a larger city.
Okay. Can we go, I'm now jumping back to relocated building shipping containers.
Mm-hmm.
So when I think about stacking shipping containers, the road on the way to Littleton comes to mind. So will the provisions avoid that type of thing from happening? Because the Heathcote area is not the same environment with the stacking of those shipping containers than it was before they were there.
So I'm not 100% familiar with the area you're talking about, but my understanding is that, yeah, you wouldn't be allowed any stacking of shipping containers. Well, that standard would trigger you to an ARDA status to try and limit the stacking of shipping containers.
So there are provisions to avoid that happening?
Yes, that's my understanding, yes.
Okay. can we go, now we're going to go to earthworks. Sorry for jumping all over the place. At paragraph 4.1.3, I'm referring to, where you talk about EWP3 requires an accidental discovery protocol. Have you read Ms Beard's reply to panel questions posed at hearing E regarding the accidental discovery protocol?
I haven't read that, no.
Well, luckily I've got it written here somewhere. Basically, she says that accidental finds can occur often in the rural and coastal areas, and also in highly modified areas. So with that in mind, would it change your view on any of your provisions that you've recommended for earthworks?
I don't believe so, because the accidental discovery protocol would apply to all earthworks being undertaken, regardless of the location. Sorry, that's what I'm...
Ms Beard also answered a question that I asked about the observer recognising archaeological or cultural material, i.e. would the observer to not need to know how to identify archaeological and cultural material when it's unearthed. Are you confident that all these people that are undertaking the earthworks have that skill?
I wouldn't be 100% confident, because I suppose everyone's different in what they would see as being an archaeological site. I suppose that comes down to an education piece when we are receiving inquiries and applications for building consents and resource consents, and whether or not the accidental discovery protocol kind of gives advice to applicants about what they should be looking for as part of that process.
So would you see AEC, for instance, providing that type of training or commissioning that type of training?
Potentially.
Okay. Thank you.
Thank you, Ms Willicks. I don't have any questions for you on your report at this stage. There may be technical matters that we raise in our post-hearing minute, but thank you very much, and thank you to the online participants, Mr Copeland, as well. Thank you.
Thank you.
Ms Vela, I think that brings us to the end of the council reports. The panel will take our lunch break now. Just checking in. Kiwi Rail probably, I'm not sure if they were going to be available at 1:15, but if they're not, but assume 1:15, otherwise we'll let you know. Thank you very much. Okay, welcome back. We're resuming the hearing F on the proposed Timaru district plan. Our first submitter for this hearing is Kiwi Rail, who are joining us online.
No, you're right.
Can see. Yeah, thank you.
Yeah, he said start again.
Okay, sorry. Welcome. We are resuming hearing F on the proposed Timaru district plan. This morning we heard from Council's Section 42 A authors, and now we're hearing from our first submitter of this hearing, Kiwi Rail. So welcome to you, and you are online. Can you hear us?
Good afternoon, Commissioners and panel. We can hear you. Can you hear me?
We're good, thank you.
I'm getting quite a lot of feedback at my end. Are you getting that as well?
Should be okay now.
Can the panel hear me?
Yes, we can hear you, and no feedback,
Okay.
so.
Right, okay, I'm getting quite a lot at my end, but we will box on. Good afternoon, Commissioners. I am Lauren Rapley, appearing as counsel for Kiwi Rail this afternoon, and I have online with me Ms. Brinlinton Hancock, Dr. Charles, and Ms. Heppelthwaite as Kiwi Rail's witnesses. As Kiwi Rail's legal submissions were pre-circulated, I don't propose to take the panel through them in any detail, but rather just to speak to some of the key points if that approach works for the panel.
Thank you.
Is the panel comfortable with that approach?
Sorry, yes.
Okay, thank you, Commissioner. I think actually, yeah, if you continue to mute, that's really helpful. I'm not getting the feedback. Before I talk to the sort of key points from a legal perspective, I did just want to acknowledge the panel's minute from earlier this week and the request for the plans showing the spatial extent of Kiwi Rail's rail noise control boundary overlay in the urban areas of Timaru. Kiwi Rail has been working hard on preparing those plans in the short time frame, and it does have a draft set that it can share with the panel as part of its presentation. We haven't been in a position to provide them in advance of the presentation, as there are some anomalies with the mapping which Kiwi Rail is working through, and some of those just require a response from other parts of the business, which it is seeking to do with some urgency. The other point I just wanted to note is that Kiwi Rail does not currently have the GIS layers in its system to also show the underlying zoning in the proposed plan and the topographical contours which the panel requested. So the plans it has prepared don't reflect those underlying elements, but Kiwi Rail was very happy to work with the council to obtain that information and can have those added to the plans and provide a finalised set to the panel. And we can, of course, following that, always appear again for a brief hearing if required to speak to those. But in terms of approach proposed as part of Ms. Heppelthwaite's presentation, that she can talk to some of those plans today if that would assist the panel.
Yes, thank you, and I appreciate what you're saying. I think probably our most immediate need is just understanding the spatial extent of the 100 metres. The panel has also earlier signalled that it intends to do some site visits locally on Friday. So
Okay.
It would assist if we could at least have something that gave us a bit of a mark as to where we can get a better sense of how greater area the 100 metres extends to through the Timaru urban area.
Thank you, Commissioner, and the plans certainly do that in terms of at least providing an indicative line, if you want to call it that, relative sort of the underlying land parcels. So we can certainly show the plans today as part of the presentation as sort of an indication, and then provide those following this to the panel, and then later if we need to add the underlying zoning and other features, we can do that to assist the panel. Turning briefly to the key points that I wanted to talk to this afternoon. I did think it was important just to acknowledge that Kirau submissions being addressed as part of this hearing do relate to a range of chapters in the plan. As Ms Hepplethwaite explains in her evidence, there is a high degree of alignment between Kirau and the Council on those matters such as natural hazards, earthworks and signs, and she can talk to those matters if the panel has any questions. Our submissions and the points I wanted to talk to today are really focused on the noise chapter of the proposed plan and the key outstanding issues between the Council and Kirau. As the panel will be well aware, the rail network generates noise and vibration, which despite Kirau's best efforts and a program to manage those noise effects, they simply cannot be internalised within its rail corridor boundaries. This means the interface between rail operations and urban development around it needs to be carefully managed, and Kirau has proposed a pragmatic and appropriate set of planning provisions to do that. The provisions Kirau seek have two key purposes, being one, to ensure the well-being of communities who live near the rail corridor, and two, to manage the potential reverse sensitivity effects on Kirau's operations. And I draw the panel to section 2 of our legal submissions, where we discuss these points in more detail and set out the legal position on reverse sensitivity effects, which, as I'm sure the panel will be aware, is a well-recognised resource management concept. It's also important to highlight in my submission there is no dispute between Council and Kirau that there should be some land use controls on sensitive activities near the rail corridor. The proposed plan, as notified, applies these controls to sites within 40 metres of the rail corridor. That is a good starting point, and we did really want to acknowledge the Council's efforts there. However, you have evidence from Kirau demonstrating that these controls should apply within 100 metres of the rail corridor designation boundary. Ms Grinland and Hancock has provided evidence on the current freight train volumes in the main South Line, which shows this is not a low volume line and also could grow in the future as demand for rail grows. In our submission, we should be protecting Kirau's ability to operate now and in the future. Dr. Charles has given technical evidence that 100 metres aligns with the assumed sound levels for rail volumes and is already a compromise to capture the most affected sites. So in our submission, we should not be reducing this any further. There are a range of technical and planning matters relating to the noise provisions where there is a difference of opinion between Kirau and Council's witnesses, which they've addressed in the evidence and can talk to today. In respect of rail vibration, which we address in section 4 of our submissions, it's important to highlight that Dr. Charles's evidence is that there should be land use controls to manage vibration effects, and Ms Hepplethwaite supports this. That was the position Kirau put forward in its submission on the proposed plan. However, it has now revised its position and now seeks an alert layer out to 60 metres from the rail corridor. This layer does not include any land use controls. It essentially just provides a signal to landowners that there will be higher levels of vibration, which may prompt landowners to consider those effects when building in this location. These layers are common planning tools, and you regularly see them around the country, including, for example, the aircraft noise notification area for Auckland Airport in the unitary plan, and also other rail noise vibration alert layers have been approved by the Environment Court in other districts as appropriate and effective planning tools. Overall, it is our submission that the provisions put forward by Kirau in the evidence of Ms Hepplethwaite and supported by the evidence of Dr. Charles and Ms Grinland and Hancock should be adopted in the proposed plan. Those were the key points I wanted to address. Happy to answer any questions the panel may have.
Thank you. I'm not sure if you had an opportunity to tune in earlier today when Council's legal counsel presented legal submissions to the panel. Did you hear those?
Unfortunately, we did not hear that presentation, okay. Commissioner.
There was a point made by Ms Vela about a possible or potential scope issue around the relief that Kirau sought in its written submission versus what it's now seeking in terms of the point at which the buffer distance or the overlay commences, and whether that's from the designation as recommended by your acoustics witness or whether it's from the rail corridor itself. And Sorry, I'll just have to grab the rule. Drafting. The point being that KiwiRail simply sought the substitution of 100 metres for the 40 metres and sought no other change to the way in which the distance was described in the rule. I really wanted to give you an opportunity to respond to that. Ms. Veely, you might better help me out quickly, what the reference is there.
Noise annoyed.
KiwiRail's original submission, as you say, sought to strike out the 40 and replace it with 100. And the way that the rule's drafted is that it's by reference to the railway line itself. But the evidence talks about rail corridor and also rail designation boundary. And so the difference between those three terms is unclear. And so it's not clear without the maps, obviously, as to whether or not the distance is sought from the designation boundary, because the rule is actually drafted as being from the railway line. And that's what the original submission sought.
Thank you, Ms. Veller. Are you in a position to respond to that now, or would you like some time to reflect on that and we can deal with your witnesses and then come back to that?
Look, it would be helpful to have some time to reflect on that. KiwiRail's position, as you note in its evidence and what it regularly seeks around the country, is that the overlay applies from the rail designation boundary as opposed to the railway, line in terms of the physical infrastructure. And the reasons for that being that the, rail designation authorises rail activities to occur anywhere within that designated land, and so it's appropriate that the controls apply from the boundary as opposed to the track. But do acknowledge the question around scope, and we will just need to look at KiwiRail's submission around that. Without having seen the council's legal submissions, the key test really from a legal perspective around scope, as the panel will be aware, is around, would that have resulted in any prejudice to any potential submitters on the plan? It would certainly be my submission, I think, that the change in terms of seeking from the rail line versus the rail designated boundary would not be completely out of left field, as the case law would say, that it could reasonably be expected that there would be controls within a distance of the rail corridor, whether that is from the boundary or the rail line. But we'll have a closer look at that point. And are there legal submissions available online that the council presented this morning, which we could refer to?
I think that point was an oral submission made at the conclusion of the presentation, but you can play back the recording of this hear that. If, contact the hearings administrator if you want a quick reference point for that. Thank you.
Thank you.
Can I just ask a question of you, just on the concept of reverse sensitivity? We've also had a bit of a discussion about that with council witnesses this morning, and I thank you for your submission, and you reference two aspects of noise being relevant for the purposes of KiwiRail's submission points, and one is obviously the well-being, and we've talked about health and amenity issues with council witnesses this morning, but the second aspect being reverse sensitivity. Yes, I accept, as you say, that it's well documented in case law as to what that means, but what is not apparent from your submissions or the evidence that has been filed to date is in the context of KiwiRail, how does that manifest itself? What is the consequences for KiwiRail if residents find themselves annoyed sufficiently by rail noise to complain? Your client has a designation, is entitled to carry out its activities. I'm just not clear. What is the effect? How is it measured, and has it occurred previously in relation to rail activities?
Thank you, Commissioner. So KiwiRail does see this play out in a range of ways, and Ms. Grinland and Hancock may be able to speak this in further detail in terms of practice around what KiwiRail sees around the country, and including in the Timaru district around potential complaints against KiwiRail's operations as a result of annoyance to those rail noise effects, and can see that as well playing out in planning processes in the future where parties living near the rail corridor then seek to submit on, proposals seeking to constrain the rail corridor's operations. But it's my submission that concept of reverse sensitivity is about the vulnerability of the lawfully established infrastructure to those potential effects and complaints and constraints. So in my submission, that there may not be particular evidence of a number of complaints or constraints having been imposed on the rail line in this district. What we're really trying to protect here through these proposed plan controls is around ensuring that that doesn't occur and that we don't end up then with constraints on the rail corridor operations. We're really trying to proactively and prudently protect the rail corridor.
Ms. Rapley, I just want to carry on that conversation because I find, so KiwiRail obviously is trying to do a blanket approach across New Zealand, and this district plan is about Timaru district, and so sometimes, so I wonder whether sometimes the understanding of the coastal service railway line is the same as a track that goes through a central area, and they're not the same. And so I get a little bit frustrated sometimes when a blanketed approach is put on into a district plan. So when you talk about potential complaints, my question to you is there complaints? Because where the railway line is in our district, the housing or the urban area, you could say is right there. If you look in the city, in the town itself, it's within 30, 40 metres of the railway line, and the housing's been there longer than I've been alive, which is quite a long time these days. But so I just wonder, the blanketed approach across New Zealand, are you having consistency, or, because I would suggest you're not, but I'd like to be proved wrong, that you need focus on the Timaru district and what's relevant for here rather than a blanketed approach. So yeah, question one is, are you receiving lots of complaints? And two, are you going for 100 metres across the whole of New Zealand?
So on the point regarding complaints, I think that's probably best directed to KiwiRail's witnesses themselves, given that is a sort of an operational question. But again, just reiterate the point that in my submission, I think it is less about sort of evidence of complaints to date and more about protecting for the future. In terms of the blanket approach, there is a degree of consistency in terms of the relief that KiwiRail seeks across the country, but it does seek to take into account, differences across the districts, and we understand the need to ensure that it is contextual. I think in my submission, the key thing to be aware of here is we talk about, urban areas and where it's built up in Timaru. As I'm sure the panel is aware, the provisions that KiwiRail seeks, only apply to new sensitive activities in those locations or alterations to them. So it is, in terms of, even though it is 100 metres from the rail corridor, it doesn't necessarily apply to every site. It would only be, where a developer seeks to, put a new house on a location or, redevelop their site and increase the intensity of that development. But certainly KiwiRail has refined its, approach around the country where there are, quieter areas of rail movements. It's refined their approach. And we see that in different parts of the country, like Whangarei, for example, where there were busier parts of the line and quieter parts of the line. And, KiwiRail has, in that case, amended its position to, reflect the contextual nature of the district and the issues there.
Yes, Ms Rapley. You said before about I'm talking about the vibration alert layer and how it's been, district plans in the North Island have taken it on board or have included it in their planning, and you've described it as that's been effective. Can you explain a little bit about what you mean by effective?
Thank you, Commissioner.
Solomon.
That reference to effective was from memory, a term used in one of the consent orders issued by the Environment Court around recognition of, I think, the value that the alert layer provides. So even though it doesn't include land use controls, I think what the court was acknowledging there is that it still has value and merit in that it is, putting landowners on notice that there are vibration effects in this location, and it enables them to then make an informed decision around, whether and how they develop in that particular location.
Have you got any examples of development using that alert layer approach? Like, have buildings been built with insulation, for instance, within the vibration alert layer?
I am not aware of, to my knowledge, in practice of that occurring, but again, it may be something that QRL's witnesses could speak to if they are aware of whether that has occurred or not. But I expect that given it is an alert layer and given that it doesn't require any, consenting or need to, notify council or the like, I'm not sure if there would be evidence yet of whether that approach has been adopted or not.
So these councils, it's just a recent occurrence, is it?
In the last few years, yes.
Okay, all good.
But I
Thank
think,
you.
Alert layers more broadly for infrastructure is not a new tool. For example, Auckland Airport's aircraft noise notification area has been in the Auckland planning documents for decades.
Okay, thank you.
Thank you, Ms Rapley. I don't think we have any more legal questions at this point, but introduce your first witness. Thank you.
Thank you, Commissioners. Now I'd like to introduce Ms Grillinton Hancock from KRL.
Good afternoon. My name is Michelle Grillinton Hancock and I'm the manager of the RMA team at KRL. I don't propose to read my statement in full, but to highlight some of my key points. It's important to acknowledge KRL supports urban development in and around the rail corridor. However, as I explain in my evidence, good land use provisions are important to manage reverse sensitivity effects and ensure communities near rail corridors have healthy living environments. The proposed plan goes some way to ensuring this, but KRL considers further amendments are required to ensure good planning outcomes. The two key points I'd like to address are first, the distance over which noise R9 applies, and secondly, the need for the rail vibration alert layer. In relation to distance, KRL seeks to extend the noise control boundary overlay from 40 metres as notified to 100 metres, and Dr Childs' evidence addresses the technical reasons for that. My evidence addresses the train movements on the Main South Line, which shows that it is not a low volume line. The Main South Line currently runs up to 8 freight trains a day between Christchurch and Dunedin, and 8 freight trains per day within the Timaru district on weekdays, with 2 train movements on weekends. KRL also expects that train movements on the Main South Line have the potential to get busier over the life of the proposed plan. With regard to anticipated future volumes, this is always a difficult question to answer as it's completely reliant on contractual arrangements which are commercial in confidence, but it is understood that we are anticipating increased volumes from McCain's, who we currently have running 2 trains a day for, and for volume from the West Coast, which is intended to go to Timaru Port. This particular, the West Coast volume has a potential to be very high, partly consented at the moment with the understanding that other sites are still being subject to consenting, and that's the mineral sands operation, which has recently been in the news. They are intending to start mining in 2027, and that volume is intended at this point in time to go through Timaru Port. In relation to the vibration alert layer, QRail now seeks instead of vibration controls. This is an important tool which puts people on notice that the rail corridor is in proximity to their property, so they can choose to change their behaviour to mitigate effects. It doesn't impose any controls on landowners, and so this avoids the council officers' concerns about costs. And the alert layer approach is pragmatic, and as Ms Ripley said, has also been accepted in other parts of the country. QRail's position is that these rail noise and vibration provisions are reasonable and necessary to protect the rail corridor and those who will live and work near it in the future. With regard to the panel's questions about complaints, I will need to talk to the regional track managers to understand what the totality of those are. Complaints, though, are not an uncommon occurrence. Just this last week, for example, in Te Awamutu, we've had complaints about noise because as a result of a new safety requirement, the shunt is required to give 4 short 1-second toots. Unfortunately, and this is to show that safety testing has been completed before the shunt runs. And unfortunately, that shunt needs to do that safety testing at 5 o'clock in the morning. And so those 4 sharp toots are occurring at 5 o'clock in the morning. And it's a new occurrence and we are getting complaints about that. So we are currently going through a process of determining whether or not we can lower the volume of the horn. Although I understand from a recent email that we can't because a shunt engine has to have a specific volume on its horn. So we are looking at whether or not the shunt can do its testing at a later period, whether we can shift the shunt testing to the location where it picks up the wagons. So at the siding, which in this instance is in a rural area, rather than at the yard, which is in the township of Te Awamutu. So we do take those complaints very seriously. At the moment, there is a lot of time and energy being expended to figure out how we can address that, and it may well end up that the shunt testing cannot happen at 5 o'clock in the morning because as much as there are no controls on the designation in Te Awamutu, QRail still does its best to be a good neighbour. And yeah, it's frustrating for those people that they, as a result of a new safety procedure, have this disturbance that is now disturbing their sleep. So that's in relation to that question. And in terms of the context for Timaru, there is a level of consistency that is being sought, but by the same token, it's not one size fits all. And for the district of Timaru, what we're looking at is the volume of trains and the future volume of trains, and that is why the provisions have been sought as they have been. But I'm happy to answer any other questions.
Thank you. Just picking up on the example that you've just used of the safety procedure that needs to occur. So if KiwiRail modifies its operational activities to address noise, you're being a good corporate citizen and responsible neighbour, and presumably there's some cost or operational inconvenience to KiwiRail to work around that. But it wouldn't be the case that activity would have to cease, would it?
We would do our best. It can't not cease because we have customers that we have to provide a service to. But we would do our best to do it in a different location if we can, or we will do modifications to the equipment if we can. One of the things that has been raised is whether we can for the safety checks, instead of it being a horn blast, turning it into a quack, which is something that is often done to replace the reversing beepers, for example, on large machinery. And apparently, and I don't understand the acoustics of this, a quack is less intrusive than a horn blast. So.
Perhaps we can pick that up with Dr. Childs, but I guess my question too was, does KiwiRail seek acoustic advice when these kind of complaints arise, just to identify whether or not the complaint is more a perceived one than an actually experienced adverse effect?
Yes, we do. Yeah. And we're also doing some noise testing to understand the exact noise level at the residential properties who are complaining.
And are there any examples where KiwiRail has offered to provide installation or ventilation for residential properties adjacent to the rail corridor?
The only examples I can give are directly in relation to projects where the designation has moved closer as a result of an alteration to a designation.
Thank you. I'll see if there are any other panel questions for you. Come back to you.
Yeah.
Yes, Ms Grinlington Hancock. Your paragraph 43, are those train trips returned?
No, they're singular movements.
Okay. That's all. Thank you.
Thank you very much for your evidence. If you could make those inquiries about complaints and provide that to the hearing administrator, that would be helpful. Thank you.
I will do that for you.
Ms Rapley, your next witness.
Thank you, Commissioner. I would now like to call Dr. Stephen Charles.
Good afternoon. I wonder if you could mute the microphone. Thank you. So as for the other witnesses, I don't propose to read my evidence. There's a couple of matters I'd like to draw to your attention, but otherwise I'll just respond to any questions you may have. I apologise, you've sort of swamped with quite large volumes of technical acoustic information. It's sort of it's a bit of a shame because fundamentally, myself and Mr. Hunt, we're well aligned that there's an issue, and that it warrants a response in terms of land use controls on new development. So, going back 5 years, there used to be an awful lot of arguments over whether we should even be talking about this, and we agree there's an issue, and the matters that we're discussing in evidence is where we disagree about the mechanics of how best to do that most effectively. And it's one of those cases where the devil's in the detail, and my evidence is if you don't get those quite right, then the rule's not going to function effectively. So in Mr. Hunt's report and in my evidence, there's quite a large number of points, and I think if I can try and get to a couple of key differences, which then a lot of the other questions kind of trickle out from. And the first one I'd like to talk about is the issue Mr. Hunt raises about 24-hour averaging of noise. So when you go and measure noise, you've got a sound level meter there, and it gives you a number all the time. And you can either take the highest number the meter gives you, or you might measure for 10 minutes and take the average level over 10 or 15 minutes, or you might average over a whole 24-hour period. If you've got a steady sound, a transformer or a state highway, often it doesn't matter how you define it. So a transformer is generating a similar sound 24/7 when it's energized, and so whether or not you average over 24 hours or 15 minutes doesn't make a whole lot of difference. State highway, there's a bit of variation day night, but it is a fairly constant source. For a railway, it makes a massive difference. for a railway where you've got discrete events, whether you average over, take the maximum level, or you average over 10 minutes or 24 hours, gives you a radically different answer in terms of the decibel number that you're ascribing to that noise source. So for most of the things that the panel are probably familiar with, this question shakes itself out quite easily. For the roads, you take a big long average, it's fine. For most of the big airports around New Zealand, there's enough movements that the averages also work out fine. If you're dealing with your neighbourhood noise, you usually deal with short-term noise, short-term levels. And we've got the railway sort of sitting awkwardly between the two. And in the appendix to my evidence, I set out where the international sort of the health studies go, and they generally work on longer averages. But in New Zealand, with the frequency of our train movements, they don't sit nicely in terms of being described by a long-term average or a short-term level. So if you describe them with a 24-hour average, you just artificially reduce the level to an extent where it's not representing the disturbance that occurs as the train goes by. Whereas if you take too short an average, then you're artificially inflating the effect. There isn't a perfect answer. So there's not. There's a technical problem there that to characterise this particular source, there's not a perfect answer as to which way you go. KiwiRail took advice many years ago from Marshall Day, and they said, well, look, a 1 hour average is probably a good pragmatic control. And if you go through the appendix to my report, so I explain the rationale for that and how that works. So what, as I say, I think that's one of the sort of the key considerations. Once you've got that use of the 1 hour average, then all the questions about how far out the distance should be flow from that, from how you define the source level. So hopefully I've explained why, in my opinion, a 24-hour average isn't appropriate, because it would underrepresent the disturbance that occurs, and I think a very short instantaneous level would also overrepresent. And my evidence is that a 1 hour average is a pragmatic control that sort of fairly represents the effects and will control the effects, and then the levels you use and the distances you use all flow on from that number. So that was the first of the 2 points I wanted to raise, was around the averaging, and I say that then flows through to the distances, which is all set out in my evidence. And then the second one is Mr. Hunt and I have proposed different ways of implementing the land use controls. So very briefly, Mr. Hunt says where you're applying the land use controls, you require buildings to have a fixed sound insulation. So they reduce the outside noise by a fixed amount, and so the inside will always be a fixed amount less than what you've got outside. So that's Mr. Hunt's preference. My preference is that you specify the noise level that you end up with in the bedroom. So if you're very close to the railway and it's louder outside, then you've got to provide more sound insulation. And if you're further away from and you'll get the level in the bedroom. If you're further away, you provide less sound insulation. If you've got your windows facing the railway, then they'll have to provide more sound insulation than if they're facing away from the railway. So Mr. Hunt's preference has the same sound insulation wherever the building is within the overlay and whichever facade of the building you're looking at. My preference, you've got to, depending on the context of the specific site and the details of specific development, you alter the sound insulation accordingly. Again, there are pros and cons with both approaches, and when you're dealing with an urban zone, an industrial zone or a business zone or a mixed use zone, and you're setting sound insulation controls, I would recommend the approach that Mr. Hunt is proposing, because you don't know where the noise is coming from and you don't know how much the noise is, and so you've just got to provide a fixed amount of that sound insulation. So in some contexts, I think that's the most appropriate use. Where you've got a road or a railway and you've got noise coming from a fixed direction, so it's only incident on one side of the building, and the noise gets less as you move away from the railway, I think it's inappropriate or inefficient to have the same sound insulation everywhere. So that's where I think the approach I prefer, which is an internal sound limit, gives you a more efficient and more effective control for railway sound in particular. There's an argument against it. It means you've got to get an acoustician to do the calculation to tell you how much sound insulation you need, but you need an acoustician whichever method you use. There's an extra step to their process under the approach I prefer, but it's sort of negligible additional effort in terms of once you've engaged that person. So I don't think that's a reason not to. So I think it's all in the evidence, but I just wanted to highlight that in terms of the detail of control, there's firstly a fundamental question about how you describe railway sound, and then there's a question about when you've got the controls, do you specify the building or do you specify the resulting level inside the building? So I think they're probably the two key points of difference. They're just the points I wanted to raise for the panel, but I'm more than happy to discuss anything else in my evidence or answer any other questions.
Thank you, Dr. Charles. Just picking up on that point, one of the questions that we had asked this morning of Mr. Hunt, but also Ms. White for the council, was just on this issue of Kiwi Rail seeks a particular method for mitigation in the context of rail noise, and you've just explained to us that that has some similarities as well for road noise. Just in the context of Timaru, where the location of the rail is and then the state highway, there are also some parts of the Timaru area that are affected by port noise. And as I understand it, the council's opted for sort of a one method that would effectively address all sources of noise rather than just focusing in on rail. Had you given any thought to that, given the context of the port as well in the mix and the location of the state highway in Timaru?
Yes, and a similar argument's been raised elsewhere. I think so in terms of the rail and the state highway, the port is largely irrelevant. It's a very small proportion of the potential exposure in the district, and you can't actually have noise that you can't have residential development in the port zone itself. So it's only affecting a very small percentage of the area. The notion that you've got to have fixed sound insulation everywhere because you need it in one localised zone, I don't see any benefit in there. Potentially you're saving yourself a few lines of text in the plan, but you're imposing a cost of unnecessary sound insulation across throughout the length of the state highway and railway corridors in the district. So for most of the district where the state highway and railway doesn't intersect with the port, you'll have noise from the railway or the highway will be dominant, and they'll be affecting one facade of the building. And the amount of sound insulation that's necessary to get acceptable conditions in the bedroom will be different whether you're 10 metres away from the road or 20 or 30 or 40 metres away. And so you're, while providing better conditions isn't necessarily a bad thing, that cost is not warranted by the exposure.
Thank you. Have you been, in preparing your evidence, have you been down to Timaru and looked at the interaction between the state highway, the railway line and its location relative to the town, residential and commercial areas?
I've been through Timaru many times, and I've worked sites on the port, and I've done rail noise surveys in Temuka and substations, so I know the district reasonably well.
Thank you. I'll just see if other panel members have questions.
Good afternoon. I've just got a question around, in your evidence, you've talked about both addressing not just the current rail volumes, but also the future. And I'm just curious as to if we were only focused on the current level of volume, would that alter your recommendation in terms of the size of the setback?
So for I think I've written it explicitly in my evidence. The current volumes warrant the size of the setback, the 100-metre setback on my evidence. And there's this, it comes down to that averaging question. So at the moment, a lot of the trains that come through are in the late evening at night. And so you've already flipped into the sleep disturbance effects, and whether that occurs in 1 hour of the night or 2 hours of the night, my evidence is that the same response is warranted. So there have been lines, most recently, say the West Coast, there's the Hokitika line's very seldom, very lightly used, and so Keyrail hasn't sought the controls on that. So if you've got one event a day and there's disturbance from that one event a day, that probably doesn't warrant land use controls changing your building stock. But on the Timaru is not in that category whatsoever. There's regular scheduled freight movements, including, I say, these ones that are coming through in the evening and nighttime hours. So the controls on the 100 metres is warranted on the current movements, and any future increase would only accentuate that need.
Thank you. And then my second question is just around alterations. So I just want to clarify, so from a noise perspective, is it the changes in the habitable spaces within a building that's the key issue, rather than the changes to the building itself?
Yes. So I think it's in the evidence. We're all agreed if you're routine repairs and maintenance, these controls should not be triggered by routine repairs and maintenance, where you've broken a window and you're replacing a window. These controls should not be invoked. If you're altering some aspect of the building that doesn't have a habitable space, then again, these rules should not be invoked if there's no noise sensitive space. If you're altering the building, altering a noise sensitive space, a habitable space, then that's when the control should be invoked.
Thank you.
Thank you, Dr. Childs. I am a lay person, so I just wanted to get that out there first. I do not have any technical experiences around this, and so when I am reading your evidence, and I obviously am reading Mr. Hunt's evidence, I feel, well, as you have alluded to, you're in differing ideas in certain areas. And when it comes, I want to talk about this 24-hour average, because Mr. Hunt is basically saying that we have little movements in the Timaru district, so we shouldn't be compared to other areas that have high movements. And in your evidence at 7.5, you say the 1 hour average proposed by Kiwi Rail provides a pragmatic approach accounting for the nature of rail noise in New Zealand. And I wonder, again, it's a blanketed statement and approach. So when we have little movement, where Mr. Hunt is sort of saying we have little movement, should that pragmatic, that one blanketed rule, shouldn't we be looking at it the 24-hour basis when we have little movement, where your comparison is when it is at a high movement? Sorry, that was a bit of a round question to saying you think it's high, he thinks it's low, so where are we at?
So I think that there's probably an unhelpful sort of terminology in terms of what does little and high mean. So if we're comparing ourselves to the Hokitika line, we've got multiple times more traffic, regular freight traffic, so it's a busy line compared to those very seldom used branch lines or infrequently used branch lines. If we're comparing ourselves to the Auckland or Wellington metro areas, and you're including in lots of passenger movements, then we don't have as many movements as those Auckland and Wellington metro areas. But in terms of the noise effects, it's the roughly sort of one freight train gives you as much noise dose as 10 passenger trains, depending on the details of the different train types and so forth. But generally, it's the freight trains that are driving the the problem in Timaru. It's solely the freight trains, and as I've mentioned several times in the Timaru, the way the timetabling works, for whatever reason, you do end up with these movements in the late evening and at night. So from a New Zealand overall, the main south line coming through Timaru is relatively busy with regular freight. But in terms of if your benchmarks, if you look at a busy European rail network, then there's nothing anywhere on the New Zealand network. But in terms of the New Zealand freight network, it's a solid bit of the network in terms of those movements.
Yes, because we've got evidence that says that we have 8 freight trains per day, which means a movement, say, I know they're at nights, but if you did it over 24-hour average, that's 1 every 3 hours, isn't it?
Yeah.
So I would consider that to be quite low.
And I think I put it in my evidence that when you look at other noise sources, you don't allow any averaging at night. So if your neighbour has, or if you've got an industrial plant next to you and some extract fan goes off in the middle of the night, they can't average that noise out over 24 hours and say, well, it was well below the limit, the 45 limit. So the way in which you respond. So some of the health effects that we look at, you've got sort of an annoyance effect, which sort of arises from the overall dose. But then there's other effects like awakenings. You're not responding to an average level. When a train, I don't know how close you live to the lines yourself, but trains aren't subtle when they go past. When a train goes past in the middle of the night, it's a relatively loud event, and if that's going to disturb you, you don't stay asleep because the 24-hour average was 10, 20 decibels lower. You wake up because the event's just woken you up. And as I said at the outset, there's not a perfect way to balance that short-term effect with the long-term effects, and that's why the 1 hour is I recommend as a pragmatic approach to that sort of problem.
Do you take into account the speed of the train? Because that is interesting that you say, as you say, a freight train going past it full speed would be very loud, but the freight train coming into our port would be going very slow. So do you take into account the speed of the train?
So the measurements, there's a sort of slightly swings and roundabouts on the speed. Sorry, can we mute the microphone again?
All the microphones were muted.
There's still one live. Thank you. That's good. Sorry, it's at our end. There's a echo. You can't. It's very difficult to talk with it. So there's the swings and roundabouts on the speed. With the train, you get a component of the sound from the locomotive engine. You get a component of the sound from the wheels. As you increase the speed, then the component from the wheels becomes more significant. As you decrease the speed, the component from the engine becomes more significant. So there are differences with speed, and in the generic data that's set out in the appendix to my evidence, that's been verified by a number of measurements and shown to be realistic, and so that's taking from trains at a range of different speeds. The levels will be reasonably representative across the range of speeds, but if you did some precise mapping, there'd be some variations along the line.
Mr. Childs, could you please explain again the difference between taking sounds on average at 24-hour average and the 2-hour average? Can you just explain why you use different averages for? Is it to do with the consistency or long-term sounds or intermittent sounds? I'm not quite understanding.
I'll try. In the big international studies trying to understand how noise affects people, they try and quantify the noise exposure that people receive against the health effects that those people present with, or they survey, either they survey or they find other sources to establish the health impacts. So in those surveys where you're looking at large populations, they try and ascribe long-term average sound levels to those people, and they're actually averages over a whole year. So that's the daily, but essentially it's akin to the 24-hour average. Right. So a lot of the evidence base that we work from says, okay, if someone's exposed to this noise dose over the long term, this is the health effect that we'd expect across at a community or population level. So where we can, so that we can relate directly to that evidence, we use those same metrics in the noise level. So that's the benefit of using a long average, a 24-hour average, is that we can relate more directly to that international research. Right. The problem comes, those long-term averages don't represent the noise effects that occur from less frequent activity. Yes. So if I've got something that's very loud, but it doesn't occur very often, then the average will ascribe it a relatively low level. So the international methods of finding a single number to represent noise exposure don't work in that situation. And so the way in which people respond to noise is complicated. It depends on a very wide range of factors and all the characteristics of the noise. So there's this very complicated response, and if you try and ascribe it to a single number, you end up with inaccuracies in how you represent that response. And so while the international method and the 24-hour averages provide a tool to help try and understand responses, that tool doesn't work in this circumstance with a less frequent source. So we've got a less frequent source with loud peaks but not occurring so often. We need some other metric to try and capture the adverse noise effect caused by that event. And there isn't a perfect way of doing it. The 24-hour average fails miserably because it underrepresents the level, and the instantaneous level as the train goes past overrepresents the level. So we've got two ends of a spectrum that we know don't work, and that's why I'm saying we should sit somewhere in the middle, and the 1 hour average provides that sort of pragmatic middle ground.
Okay, I think I get it now. Thank you. Thank you. I just have one more question. At your paragraph, I think it's 5.4, yes, 5.4, your table, distance from track sound level, I noticed that the 90 metres has a 56 decibel as well. Why was that not chosen? Why was it the 100 metres and not the 90 metres?
I was trying to get to 55, and but by the time I can't remember what the exact decimal points were there, but I think the 100 would have been close enough to 55. That's where the round number where it landed. So it probably should have been 110 or 120 in reality, but it's been capped at 100. So,
but you chose 100, and yet 90 metres says the same. So I'm asking why was 100 metres chosen and not 90 metres chosen?
So there is a difference between those numbers. The difference is not portrayed because they've been rounded to the nearest decibel. So the 90 metres is louder than the 100 metres. The technical advice is that the control should go out to more than 100 metres. So my advice to Kiwi Rail would be that control should extend for a further distance. The 100 metres is the pragmatic cap that's been placed on the controls not from a technical perspective.
But the distance, 90 metre distance, is higher than the 100 metres distance.
Yes, and that's lost in the rounding.
Right. Okay. Good. Thank you.
Thank you, Dr. Charles. Can I just further question I had for you? I talked to Mr. Hunt this morning about the sort of hierarchy of annoyance levels from different noise sources, and he, as I understood his evidence, agreed that aircraft noise is probably of a higher annoyance level than road traffic and rail less than road traffic. Do you broadly agree with that?
Yes, and there's lots of there's New Zealand research and there's international research where they look at in terms of annoyance response. Rail traffic is generally deemed less annoying than road and rail, air and road for the same level. So that, again, that's so as a general proposition, that's right. You just got to be careful on that 24 average versus individual events again. The individual rail event is louder than the individual road event, so there's so some of the nuances being lost in the 24-hour average between those comparisons.
And obviously people's response or reaction or the annoyance levels is complex, as you say, as to what might trigger somebody to actually complain. At 8 train movements a day currently, even if they're in the sort of later part of the day, in your opinion, is that likely to create an adverse health impact on the community?
Yes, yeah, and I think that's the key point in all of these hearings. From a legal and planning perspective, sometimes the reverse sensitivity and the complaints sort of, in my view, takes undue precedence. From a technical perspective, the adverse effect is there completely regardless of whether complaints occur, and complaints can be quite a bad indicator of whether or not the effect is occurring. So from a technical perspective, the adverse health effect will be occurring. Whether or not complaints arise is a secondary matter to some extent.
And sorry, just in other contexts, I do recall evidence, and I can't precisely recall where it was, but just anecdotal evidence that I've heard in the context of noise is that rail noise is sometimes tolerated by people more than, say, the consistent noise of traffic or even aircraft noise. And I think it was explained on the basis that people get used to sort of the time of the train, or if they live in close proximity to the rail. Do you agree? Are you aware of any research in that area, or that would confirm that?
So only in terms of those average levels we were talking about before. So there's clear evidence that for an average level, internationally and in New Zealand, the community is generally more tolerant of rail noise than the equivalent level of road or air noise. The thresholds at which health effects occur based on that research is the same as the thresholds at which we've sort of proposing controls here. So that is taken into account in the numbers that we're looking at.
Thank you for that, Dr. Charles. There are no further questions for you. Thank you for your evidence.
Thank you.
Hopefully your last witness, I think.
Thank you, Commissioner. Last but not least, Ms. Heppelthwaite.
Good afternoon, panel. I'm Kath Heppelthwaite, a planning consultant. I'm providing evidence for KiwiRail today. By the sounds of it, you have read my evidence, and as Ms. Ripley has said, there are a range of topics covered today, and I'm just confirming that I'm generally either in agreement or accepting of the recommendations of the topics which we have discussed so far outside of noise. There is one minor correction I'd just like to draw your attention to, if you'd be so kind as to turn to my appendix on the plan provisions. So if we go to the back of the documentation, your page number momentarily, and in particular, I'm looking at the changes that I proposed to Policy 5.
And my apologies, panel, I can't actually see you in enough detail to tell if you are able to keep up where you're at. So please let me know when you've found that and I will explain to you what's necessary.
Sorry, can I just confirm, is that noise P5 reverse sensitivity you're referring to?
Yes, that's correct.
So it's on.
You'll see there.
It's page 20 on the evidence.
Thank you.
Much appreciated. Thank you. You'll see there that I proposed deleting the items 1 to 4, and there I should have also deleted, for grammatical correctness, the words while taking into account. Because obviously if the chapeau clause remains, if the commissioners are mindful to accept my recommendation, the words while taking into account would not be necessary with the removal of 1 to 4. I wondered if there's two things I'd like to offer to support you with. One would be to walk through the conditions in my attachment, but I thought perhaps you may consider that. What might be more helpful perhaps is to address your earlier question about the maps, and if I would be able to share screen and share some of the maps for the urban area of Timaru.
Yes, do that. The maps would be helpful, thank you. Please,
yes,
please walk us through the maps.
Can you see my screen? Excellent. So what we have here is a series of 31 maps. They start at the very northern end of the Timaru district and they progress in bite-sized pieces to the south. The grey lines are cadastral data. You can see all the property boundaries and street names, and the heavy black line in the middle is actually a representation of the rail tracks. You'll see that we're focused on the key yard area within Kiwirail, and the blue lines are 100 metres measured out from the edge of the designation. You'll see in the middle of the map there's a little red spot that says Caroline Bay. Hopefully that, I'm sure that enables you to orientate yourselves. I will just zoom in a little bit so you can get a bit clearer picture of how that looks. Oh, my apologies, I scrolled maps here instead of zooming. I'll zoom in using this. So you can see there that the maps themselves have got quite a lot of detail as to where they sit relative to cadastral boundaries. As Mr. Rapley has alluded to, there are other layers which you've requested, which we are still working on, and there are a few anomalies where there are some areas of Kiwirail land which is owned but doesn't necessarily generate noise, and we're looking to remove those. And actually I will just give you an example of that just so you can see the types of I'll call it auditing which occurs. I'll just go to the last page on the map. This is the very southern boundary of the Timaru district. You'll be able to see there is a bubble shape blue line on the left. That's an area which we will be looking to audit out and make sure that the line actually runs parallel with the rail line rather than extending into surrounding land. And those of you who are extremely alert will also notice that the blue line actually stops slightly before the edge of the Timaru district boundary, and that's another example of matters which Dr. Charles and I look to check and ensure that we give the most accurate information available with the maps in conjunction with Kiwirail's GIS specialists. I hope that's helpful. It's probably more interesting to you. I'll just slightly scroll up the line heading north back towards Timaru itself. You'll be able to see that the setback is fairly consistent. Where you see bubbles like we've got here on Catherine Street, that's because the extent of designation or land is wider at that point. You'll see here we're right at the south side of Kiwirail's yard, so there is more land available there. I do appreciate this is much more useful with the aerial photos underneath. And you, of course, will be much more familiar with the localities than I am. Do you have any questions on these maps?
think that's quite self-explanatory. Thank you. That will certainly just assist with our site visits at the end of the week. It's represented from the boundary of the designation. Is that correct in all cases? And rather than the rail line itself.
Yes, that's my understanding.
Is there one map further north than that? Or is that where it starts? Is there?
Oh, this is map number 23 of 31. If I actually go right to number 1, you'll see it starts at Rangitata Island Road approximately. It actually starts in the middle of the Rangitata Bridge. That's, if you can see my cursor, this area
excellent.
here.
Thank you.
So then they just step down, but I will go back to map 20 for you. Does that look to be of interest? Actually, sorry, 21, I think. Oh, no. Smithfield, yes, Smithfield would be the next one north.
Thank you for that. Ms. Hebblethwaite, I don't think you need to take us through the provisions and the drafting. They're quite clear in your written evidence. Unless there's anything else that you would like to add at this point, I think we'll just move to panel questions. We're a little short on time, if that's okay.
Yes, happy to answer questions.
Good afternoon. I'm going to start, and I've got a really ridiculous detailed one. I just want to make sure I'm understanding properly. And it is in your appendix, and it's, just lost it now. It's noise standard S3. And I really just want to understand, it's the standard one that starts any habitable room. Have you got that one? The part I just want to be really clear that I understand, it's the part that goes, this third line, or an alteration to an existing building that changes its use to a noise-sensitive activity. I just want to be really clear. Are you talking there about the alteration that changes the use of the building, or it's the alteration that changes the use to the habitable? I just want to be... Sorry, that came through quite weirdly. Is it the change... Is the reference to change referring to the alteration, or is it referring to the building? The way it's worded there.
If the building currently does not accommodate a noise-sensitive activity, and there is an alteration which puts in a new noise-sensitive activity, that would be captured by the rule. Does that answer your question?
Change of use.
Yeah.
Change of building.
Yeah, so that would cover a change of use.
Yes.
So if you've got an existing building, this is what I want to check. You've got an existing residential building and you're adding on a new bedroom, your intention is that that's captured, isn't it?
Yes, and the other circumstance that would apply would be if there was, for example, an existing warehouse and maybe it changed to perhaps a childcare facility. So there's no physical change to the building, but there is a change in use which goes from not being sensitive to noise to being a noise-sensitive activity.
Right, okay, thank you. I'm clear on what you're intending, that's cool. So my next question then goes to the vibration alert level, and I'm just keen to know what the policy you're relying on is. Where does that come through in terms of objectives and policies? Where's that linkage, please?
That is an excellent question. I may need to refer back to you on that. I'm just having a quick browse back to the RPS, which is a tier above, obviously, where the district plan sits. Just looking back in my earlier provisions. So if I may refer you to page 6 of my evidence, actually it's numbered page 5 and a hard copy in PDF page 6. And under Roman numeral
Sorry, I'm slowly
7,
getting there.
you'll see policy 536, and underneath item 2, which requires territorial authorities to, and I'll leave you to read the text here, but basically it says avoid land uses that may result in adverse reverse sensitivity effects on transport infrastructure.
Yeah, sorry, I was meaning within the Timaru District Plan noise chapter.
Yes, I will need to come back to you on that.
Right, thank you. And I think it's particularly given it's going to be an alert level, not a management implementation. That was what, because when I read through the current policies in the noise chapter, I didn't see anything that really led me to understanding there would be an alert level anywhere relating to vibration.
Perhaps I can answer that question by providing an alternative response rather than policies. If I may refer you to hard copy page 19 of my evidence, and there you will find, or PDF page 20, there you will find text I propose to go into the introduction of the noise chapter, and that explains the purpose of the rail vibration layer. And just thinking more broadly on your question of policy support, I think I will come back to on that simply because it isn't actually a rule in the plan, but it is a method proposed. So I do think there is some required. But as a start point, that is included in the introduction to provide guidance to plan users.
Right, that's right. So is your understanding that methods don't need to implement policies or objectives?
No, other way around.
Okay, right. So it might be something you come back on us then.
Yes, ma'am, if that's suitable.
Thank you.
Ms Hebblethwaite, I've just got one question for you just in relation to the Section 32 report that you've appended to your evidence, which I understand that you adopt as the Section 32 AA analysis, I guess, or what, Section 32 analysis for Kiwi Rail's proposed rules package. Is that correct?
Yes.
I just wondered whether or not you had, I can't find any reference into the report itself, but did you consider the option that's proposed in the district plan in terms of the 40 metres distance as part of the Section 32 evaluation?
Yes, I've been assisting Kiwi Rail in various jurisdictions across the country, and there are, as you can imagine, a range of approaches from different councils, ranging from no setbacks through to the 100 metres that Kiwi Rail is seeking. And as part of my broader experience, I have considered 20 metres, 40 metres, 60 metres and 80 metres. So whilst not specifically in here, it is something that I have considered, and it is my preference, as I've said on my evidence, that the technical evidence of Dr. Childs at 100 or more metres is an appropriate level to set that at.
Thank you for that. Look, there are no further questions from the panel. Thank you very much for your evidence. And Ms Rapley, unless you've got any brief concluding points, we'd like to thank you very much for your submission on the plan.
Thank you, Commissioners. I do have a couple of very minor points just to wrap up, and then did just want to confirm in terms of next steps and our homework, if I may, briefly. The first point was just to confirm around the volumes in this district. So there was quite a lot of discussion with Dr. Childs and the panel around 8 movements per day. But I did just want to refer you to paragraphs 4.3 and 4.4 of Ms. Grinlington Hancock's evidence, where there is reference to the movements travelling through the district, so between Christchurch and Dunedin, but then also train movements within the district. So that equates to 16 per day rather than 8. And the other point I just wanted to look back on was just around the scope discussion we had at the start of my presentation in terms of Kiwi Rail's submission referring to the railway line as opposed to it now seeking through Ms Hebblethwaite's evidence that the 100 metres be measured from the rail corridor designation boundary. So if the panel does have KiwiRail's submission there, I wonder if that might be helpful just to turn to that briefly. And in particular at line item 73. Sure.
Lost it and the tabs open on my laptop.
No problem. I know what it's like when you've got multiple documents. Look, the point I just wanted to make there was the relief specifically sought does, I guess, delete the 40 metres and states the 100 metres of the railway line. But the reasoning for that submission more broadly in the column prior does talk about sensitive uses within 100 metres of the railway corridor, and which could be interpreted more broadly, and also the new standard that KiwiRail sought at that line item for permitted activity 3 also talked about new buildings containing activity sensitive noise closer than 60 metres from the boundary of the rail network is designed, constructed and maintained in accordance with standard noise 7. So certainly there is could have been additional clarity in KiwiRail's submission, but it is my submission from a pure legal scope perspective when we think about the impact of the change that KiwiRail is now seeking. It's my submission. I don't think there's any real risk that persons directly affected by KiwiRail's submission would not have had the opportunity to participate in the process, because landowners, in and around the rail corridor were on notice of those proposed changes in terms of KiwiRail seeking controls, within our distance of 100 metres of the rail corridor. So certainly there was notice there. They could review KiwiRail's submission and, make their own inquiries as to whether they wished to make a further submission on that.
Thank you for that.
That's all I wish to address. I did just want to follow up about homework, and I had noted a couple of questions the panel had. Firstly, to Ms. Grinderton-Hancock in terms of data on complaints in the Timaru district, and then the discussion just before with Ms. Hebblethwaite around the policy basis or not for the vibration alert layer. We also have the homework around the plans, and so just wanted to confirm whether the panel will be issuing a direction in that respect or whether we should just box on and provide the information as soon as we can.
I think that you can box on and gather that information. The panel will do a wrap-up minute at the conclusion of the hearing, but don't let that stop you from getting on with the job. Thank you.
Certainly. Thank you, Commissioner, and we'll aim to get those plans through as soon as possible, given the site visit on Friday.
Thank you very much.
Thanks all. Appreciate your time.
Right, our next submitter this afternoon is Jetboat New Zealand Limited. If you can come forward and take a seat. Welcome, just when you're ready. Push the button when you speak and push it again when you stop.
Oh, makes sense. Well, look, thank you, hearings panel, for the opportunity to come and speak to you. My name's Malcolm Smith. I help Jetboating New Zealand with some of their regulatory work throughout New Zealand, and I've prepared this statement that you should have in front of you, or you've had an opportunity to read. The thought being that hopefully it will just lay out the key matters, and I don't wish to directly read the statement. I think it stands for itself. What I'd like to do, and particularly with the time available, is just to perhaps focus on the key issues. I'd like to introduce next to me Ronald Clearwater, who's the chairman of the Rivers group of Jet Boating New Zealand. Ronald is also a very expensive, a very experienced jet boater, happens to live in Geraldine and therefore is very familiar with the waterways within the district. I'm also a jet boater, not nearly as good or expensive as Ronald. So for my sins, I help more in this space. Ronald's more on the water. In my statement, I'm not going to talk to it. I've just done a very quick introduction, which I've kind of just talked to now, and then I've just on page 2, starting at item 8. I've just outlined a little bit about Jet Boating New Zealand as the submitter. Again, I won't talk to that. And then on page 3, headed submission, I've just outlined the key submission points that Jet Boating New Zealand has made. Again, I won't necessarily talk through that, but it should ring true with the original submission document. If it doesn't, please someone let me know. We've worked through the exercise and taken quite careful note of the Section 42A response and the recommendation to the panel, and that's probably been the key focus to then provide this statement and then present to it today. So I'm aware of the time constraints, so I will try not to talk too much, but I do want to just raise probably 2 or 3 key matters. Let's just skip over the objective. We've made a submission on that. I think it speaks for itself. Coming to policy 3, which concerns the non-commercial, and let's call it recreational jet boating activities, we made the submission seeking a change to the policy wording to recognise the nature of the effects to a degree, and then also we have a broad view within Jet Boating New Zealand that it's reasonable to control the jet boating activity, the recreational jet boating activity, with reference primarily to water flows. And the view being that jet boats need a certain amount of water to be able to actually then safely navigate. With the limit, in this case 20 cubics, our view is that the other users of the river or the waterway are unlikely to be there to then create the potential for conflict, and that's particularly fishermen and other users of that nature. Also considering the river bird nesting and those sort of things, at those flows there's very likely to be significant disturbance that the addition of jet boating activity won't have a material effect. So the basis of our submission for the policy and then flowing through to the rules on the specific rivers is that it is reasonable to impose a minimum flow limit to then enable recreational jet boating, and it is not necessary to also have a time of year sort of permitted standard or restriction on the basis that the reasons for that won't exist when those flows are at those minimum levels. That's the way we feel about it. The view is supported by, and I've referred to it directly, the exercise of Plan Change 19 to the Mackenzie District Plan that occurred in, I think, 2019, where Jim Jolly provided evidence talking about the effects of recreational jet boating on riverbed birds. And in my statement, I've just drawn a couple of findings from that evidence. So if you go to item 22 of my statement, the evidence of Jim Jolly has been summarised there in terms of items A through to F. And so that's substantially why we hold the view that we do. We also have an anecdotal type perspective where we observe on quite a regular basis the effect of our recreational jet boating activities on nearby birds, and the view is typically that there is no disturbance of any great note. So that's the position that we typically hold. That's how we formed the submission that we put into to this particular district plan review, and that then flows through, excuse the pun, to the specified rivers. Through the process, and we thank you, Andrew, for facilitating that discussion before the hearing between ourselves and DOC. We discussed the issue of the effect of jet boating activities on the riverbed birds, and we took note of DOC's view that there should be a 6-month restriction, and as they said to us, it's on a precautionary basis, and I think they used the term irrespective of the effects, a death by 1,000 cuts will nevertheless create the death. So we went back to Jim Jolly quite recently and we asked him to just give his perspective on these specific rivers. And what I've included in this statement is a statement from Jim that then just reaffirms our view about the general lack of disturbance of recreational jet boating on the riverbed birds. However, picking up on Jim's view that there is the potential for some disturbance over the months of September through to November in the case of the fledglings and the other ones, the young ones. And then after talking to Jim, he convinced us that maybe that September through to November should cautiously extend from September through to December. So notwithstanding our broad view, we've listened to Jim, and so we're really coming back saying we would like the opportunity to be able to boat the rivers noted as a permitted activity with that minimum flow, because we believe that minimum flow is really the most effective mitigator on effects, but also recognising that September through to December period where with a degree of caution it's better that we just don't go there. So where we've got to is to make some recommendations to change slightly the recommended conditions to both the policy and the rules, just to reflect that. And we'd be delighted if that was carried through and then became appropriate policies and rules in the what will become the operative district plan. So, just with time available, are there any questions on just sort of where we are and how we've got to this position now that we can respond to?
I just had a question in terms of the work, the extra work that you got. It's Mr. Jolly, isn't it, not Dr. Mr. Jolly.
Yes, I believe so. Yep.
You don't know, did he? Did he, you don't know if he went back to DOC and discussed the issue at all with their expert? I just note there's a difference between Mr. Jolly's conservative approach being September to December and DOC is suggesting August to February.
Yes.
And it would have been
it's degrees of
useful
conservatism.
for us to understand what the difference is
Yep.
from Mr. Jolly's perspective.
Yep. Well, Ronald, if you can help respond to that, that would be fine.
Jim did do some homework. I don't believe it was specifically with DOC, but he did reference the riverbed surveys that happen. Some rivers it's biennially, some years it's every year, and ECAN and some of the river protection groups undertake them. And with that culmination of that information, that's where he got that time frame of September to November.
Okay. We can ask DOC as well whether or not what their response is to that suggestion. But thank you for that.
Yeah, we are certainly just taking note of what Jim has had to say. We value his expertise and his experience, and it seems to have been applied specifically to these rivers, which is something I'm not convinced has been the case with the DOC commentary.
Okay. All right, we'll leave that with us. And I just wondered, it might be just helpful for us to understand a little bit more about the sport or the recreation of jet boating, and whether there, aside from the obvious constraints that arise with river flows and the like, and potentially ecological constraints, what's the preferred time of year that jet boating occurs, all things being equal?
Whenever the sun shines.
It's a daylight activity.
Yeah. Maybe I can answer insofar as it's not a traditional seasonal activity. It sometimes is dependent on the weather conditions, but I'd suggest to you that it's more a case of the river conditions that will then determine whether we go out and do our jet boating, and then the circumstances surrounding that. It's interesting, we undertook a values study by Dr. Galloway in 2020, which was published. It was, if you like, reading 300 odd pages, and he helped us immensely to understand the values associated with our jet boating activity. And amongst other things, that's helped clarify, why we do it and what we're looking for in the circumstances surrounding it all. Sadly, it's very diverse, but nevertheless, it does probably reaffirm that it's an activity that can and does occur throughout the year, so it's not seasonal. And it's quite varied to range the specifics of the people and the rivers and the environment and, people's perceptions of values. Sorry, that might be a long way of answering that.
It's helpful for me. I'll just see if the panel have other questions. Well, unless there's something more that you would like to add, and
if I could,
you've got time, so.
Yep, we should do. Jet Boating New Zealand has not only sought some opportunities to boat the specified rivers with their associated river protection areas, but we've also sought approval to expand the waterways to the 3 other rivers, and hence we're suggesting, I think it is proposed Rule 11. Mm-hmm. And just to say that we have applied the same sort of approach to considering those waterways as we have for the Orari and Opahi and Pariora. Again, we've asked Jim about those rivers. He's not so familiar with them per se, but he has spoken with Environment Canterbury and 1 or 2 others in that ecological kind of space in this part of the country. So he's been happy to extend his statement towards those rivers as well as the ones within the originally identified within the proposed plan. So, sort of in summary, we would very much like the opportunity to boat those rivers when the circumstances are appropriate as a permitted activity. We think doing so is not going to unreasonably cause adverse effects on others or the habitats or the environment. And as probably a final comment, our view within Jet Boating New Zealand is to enjoy but share the resource. And this is probably quite a good tangible example of how we think that we can enjoy and get benefit from the resource, but in a kind of a sharing, respectful way, considering other users and other circumstances. So we're not shooting for the stars. We feel that we are asking for a pragmatic opportunity, and we probably can finish by saying we seek the panel's assistance, please, to enable us to get there.
Okay.
Ronald, do you have anything else?
No.
So that's all from us. If that's all from you, then...
Thank you. That's helpful, and thank you for the constructive way that you've engaged with Council and with the department to date. So we'll hear from the department. I think they're here tomorrow. So
yeah, and if there is any benefit in further discussion, we'd obviously be very, very happy
absolutely.
to...
Thank you for that.
To, just to continue the things. All right.
All right. Thank you very much.
Thank you very much.
Right, well, we'll take a break for 15 minutes and return at 3:15. Welcome back for the afternoon session. We've now got a submission from Apoha Dam Limited and a submission from the Terrace Timaru Limited. If you can come forward, that'd be great. Thank you.
Thank you.
Timaru matter first and then get into the Apoha.
Yeah, I can do that if that's
That'd be
easy.
good. Thank you.
So I've just prepared a very short couple of pages, but I'll just speak to it to make the time a little bit more efficient for the panel. So just simply wanted to thank the panel for attempting to accommodate our request to have Mr Gresson, the primary witness for the submitted, and appreciate the difficulties around that, but we're more than comfortable providing any written response if that becomes necessary from the panel's perspective. There was just one other point that I just wanted to quickly work through, which relates to the Kiwi Rail evidence in relation to reverse sensitivity management. And it really has just cropped up through that final review of the evidence that came through a couple of weeks ago. There's obviously some changes that Kiwi Rail seeks in relation to those provisions, which include 2 new overlays, planning overlays, which were not actually sought in the submission, original submission of the submitter. The submitter, 22, the Terrace, just has concerns about whether or not that raises some natural justice issues, bringing in an overlay now when parties or owners of properties in particular would not have been aware that that would be coming, and it's a significant change in terms of the area that would be affected. It's going from 40 metres to 100 metres. I'm just conscious that the panel's raised natural justice issues previously in relation to some of those overlays and extensions of them. So it was just really to just alert you to that and to respectfully request that that be considered in your consideration of the Kiwi Rail submission. And I've also noted there that Section 42A report is recommending the decisions sought by Kiwi Rail in relation to that 100 metre setback requirement be rejected for various reasons, including some acoustic evidence from Mr Hunt.
Thank you for that. And look, we will look at that. Just an immediate thought. I mean, the Kiwi Rail submission clearly stated a requirement for the 100 metres to be identified, and I guess whether or not that's just simply expressed in words in a rule or whether it's reflected on a planning map, which is another technique to display just like a zone boundary, and you have to know where it applies.
Yes.
Yes. Might fall within the bounds of scope, and we will have a look at that. But we had a conversation this morning about some of the extensions of the overlay relating to flooding, for example, where the submitter concerned with ECAM was simply just asking for an extension of the notified overlay without sort of any maps to accompany it. And look, we're alive to these issues and we'll give it some thought, but I just note that the submission clearly stated 100 metres as we...
Yes, I did. I guess the one issue that's come across through this evidence is that you've got different sort of planning approaches, for example, for the port, which is why we kind of became alert to it, which is using an overlay, and it's a similar sort of area that probably goes further inland really from the port, and then you've got these which are embedded in policy and rules. And so I guess from the submitter's point of view, being able to pick up the plan and the planning maps and see an overlay for one thing, they'd probably expect that any other related sort of noise insulation requirements would also be mapped in that way. So it's just, I guess it's just, yeah, the different approaches within the plan, and there needs to be some consistency, I think, and at the end of the day, to make sure it's easier for plan users to understand what limitations on their property are, and also plan implementers. So, yeah.
Yeah, and your point's well made. At the end of the day, the plan needs to be usable and readily understood by the people that it's prepared for. So thank you for drawing that to our attention.
So we'll move to the Opua submission. Ms Crossman's here today appearing with me. We haven't prepared any legal submissions. We thought it was probably sufficient to just provide some evidence from Ms Crossman. She has prepared a summary, and that is primarily in light of the discussions she's had following the filing of evidence with Mr Willis, and that's resulted in some refinement to the matters that Opua now wish to pursue at the hearing. So I'll hand it over to Ms Crossman, who will just talk through those changes and is able to answer any questions that the panel may have.
Thank you. Welcome, Ms Crossman.
Thank you. I understand you've all got a copy of the summary in front of you. So as Georgina said, I have had a discussion with Mr Willis, and we talked in relation to NHP3, NHR1 and NHR3 in particular. NHR3 specifically in relation to the applicability to the beds of surface waterways, and the intention to avoid duplication. The areas that we didn't discuss, or that I haven't discussed with Mr Willis, include NHR4, NHR3, the other elements of NHR3, NHP8 and EWR1 and EWO01. So those, I'll address each of these in turn. So in terms of the discussion points that we've had with Mr Willis, so NH Policy 3, in relation to this, and I understand Mr Willis covered this morning as well, we had concern around the term native habitat and confusion that could cause, and we spoke around possible amendments to that, either rephrasing it to make it clear that it's native vegetation or deleting it, and either one would be happy with and would address the concerns that I had in my evidence. In relation to NHR1, and this was a misunderstanding of mine in terms of the intent of the notes, and Mr Willis has explained that NHR1 does not require compliance with the standard NHS1, and so that addresses my concerns raised in the evidence also. In terms of NHR3, Mr Willis expressed he didn't intend this particular rule to apply to activities in beds of surface waterways, and I understand Mr Willis covered this morning as well in questions. And to address this, he suggested adding further clarification within the natural hazards chapter rather than actually altering the planning maps. I also understand that Mr Willis is considering other aspects of my submission in relation to this particular rule. But I do agree that the intended amendment would provide the necessary clarification regarding the intended scope of NHR3. Regarding NHR6, and I guess as a consequence of clarification received regarding the NHR1 Mr Willis and I both agreed that the assumption I made in paragraph 4.21 in my evidence is now sufficiently addressed also. And I also understand in relation to UNHR6 that Mr Willis was going to further consider the options relating to this rule in terms of permitted or controlled activity status. So the remaining matters outstanding that I'll wish to pursue are those in relation to NHP8, NHR4, NHR6, EWO1 and EWR1, as I've addressed in my evidence. And these outstanding issues largely relate to the recognition of regionally significant infrastructure in the policy and rule framework. I understand elsewhere in the plan distinction has been made between regionally significant infrastructure and other infrastructure. In relation to NH Rule 6, permitted status for regionally significant infrastructure is preferable. However, if there is concerns regarding the appropriateness of permitted status, a controlled activity status would give us sufficient certainty and would be an appropriate way to address our concerns, as well as recognising the significance of that regionally significant infrastructure. Regarding the earthworks Rule 1, as Ms Willicks has referred to Mr Willis's analysis of NH Rule 3, if amendments are made to that NHR3, I believe the intent can naturally flow through to earthworks R1 also. And finally, regarding earthworks objective 1, whether reference to the regionally significant infrastructure is required is really dependent on whether that earthworks chapter applies to regionally significant infrastructure as outlined in my evidence, and clarification is sought on that. So that's my summary, but I'm happy to take questions, clarification.
No, look, thank you for that. Look, that's all clear. The panel asked questions of Mr Willis this morning and clarified that issue in relation to the native habitats, Indigenous or native habitats, and reiterated that that you could effectively land in a position where you just revert back to vegetation as being capturing the intent of the change. Mm-hmm. But I don't have any further questions for that on those matters. So thank you very much for your statement. That was simple.
Appreciate your time.
Thank you. Thank you. And we're now joined by House Movers New Zealand Heavy Haulage online, Mr Barnard Thompson. Welcome.
Thank you.
I'll turn my mic off and leave you to it. Thank you.
Okay, now that's great. Firstly, thank you for the opportunity to appear by Teams. We're based in Wellington. We're a national association of transport operators, and so obviously this is an efficient way for us to represent the interests of our members. And also this gives us an opportunity to present in more detail about the district-wide provisions for relocated buildings. Previously, we did anticipate that we would attend the B1 and B2 hearing last year to advise what our approach would be for relocates. And I do note in our submission that we're actually incorrect in saying that we did appear. We did agree to appear now, and this is, of course, the most appropriate time, so which is good. Now, while our interest is to get a consistent requirement for relocates across all regions and zones within the plans, we note that in some areas like the port zone that there are more specific or particular requirements there, and we don't oppose those particular things, but we do seek an overall, approach to relocates. So we now have available the 42A report. We're pleased to see that this supports the approach that we've been advocating to the Council since 2020 when we first submitted feedback about the draft plan. We agree that a permitted activity option for relocated buildings with agreed performance standards is a good balanced approach for the management of relocated buildings, including recycled houses. And the staged reinstatement of a building onto a new site, with it required to be on permanent foundations within 2 months, and then the complete finishing of the job within 12 months, places this within the timeframe of construction of a new building on site. And so that the effects of the building or the reinstatement, in our case of relocated buildings, is not dissimilar in our view. Now, the use of the relocation report that identifies items to be reinstated means that there's an agreed set of tasks to complete, that the house owner agrees to complete within the 12 months. And it's pleasing to see that that's been adopted or recommended for adoption in the 42A report. Now, for those relocation projects that don't meet the performance standards associated with the permitted activity, then the control reverts to restricted discretionary, which allows the council planning officers more control and influence over the project, including the ability to impose a financial bond if necessary. So in my view, this regime encourages house owners relocating a building to make every effort to ensure that application will comply with the permitted activity standards, and we think that that is a good thing. Now, just noting a couple of other things in the 42A report. So we don't oppose that heritage buildings are excluded from the relocated buildings definition. We think it's right that these buildings have their own set of rules and requirements. And in passing, I note that also within that definition, that newly constructed transportable houses are excluded from that reinstatement requirements, which we think is appropriate and fitting, given that they arrive to site in brand spanking new condition. It's assumed that a relocated building would need to comply with the rules and standards relevant to each zone, and we will be comfortable with the advice note mentioned in 10.4.10 in the 42A report. And finally, of note in the 42A report, so the removal of the licensed building practitioner involvement, so that's acceptable to us, as an LPB may not be required for most of the reinstatement work anyway, and the onus has to be on the house owner to complete the work, and that's where the responsibility, in our view, should lie. So overall, we seek the considered view of the hearings panel to endorse the view of the 42A report, and also our submission as the industry association that represents house movers nationwide. We have been making submissions to district plans around the country since 1998, and since that time, every council that we've submitted to since our 2004 Environment Court appeal that we lodged against the Central Otago Council now has permitted activity option for relocated buildings. And of note, the Central Otago Council last year confirmed permitted activity status for relocates in the revision of their plan, taking on board the template pre-inspection report that we have developed since the council appeal win back in 2004. So really that's the end of my specific points that I wanted to identify from our written submission, and I welcome any questions from the panel.
Thank you for that.
Yes, Mr. Barner Thompson, I'm trying to find now. I did have a question for you, but I can't now find the part, because as I understand it, the only thing that happens before a moving is billed is a visual inspection. Is that right?
Yes, I guess it is. I guess that's fair to say. So there is a report that is completed by a licensed building practitioner that identify those aspects that need to be reinstated when the building gets inspected. So, and it is an external report. Yeah. So obviously it's more an amenity evaluation. But I guess there are aspects of the building that need to be safe and sanitary, for example.
Right, so because I was trying to reconcile your 5.2, your paragraph 5.2, listing all the things that needs to happen, physical things, with a visual inspection only, and I couldn't reconcile that. So it's just...
I understand the point that you're making. So I would say that there are lots of aspects of the process of relocating a building that are separate from that visual inspection. So the visual inspection, that pre-inspection report, is really for the council to understand what aspects of the building need to be reinstated once it gets to site. So for example, let's say that there's no spouting, right? Yeah. So that can be identified on the report and the spouting can be reinstated once, or, you know, installed once it actually gets there. So a lot of those other aspects in 5.2 relate to other steps in the process, you know, so like the disconnections, and I guess, so the consenting would probably include, you know, like plumbing and electrical installation, right? So all of those aspects are covered by other consents for other processes. The foundations, you know, so you need a new consent for that, which is signed off by the LPB. So there is other processes and checks and balances involved.
Okay, but the visual inspection's done by a registered builder, is that right?
Well, licensed building practitioner is what we call them these days.
Licensed building practitioner. Yep. Okay, thank you.
No problem.
Thank you for that. I don't have any questions for you. Thank you very much for your evidence and your submission. Thank you.
No problem. Thank you for your time.
That brings us to Fonterra, so please come take a seat.
Start again. Well spotted. Commissioner Scott. So good afternoon. Yet again, you're hearing from Fonterra. I almost feel I have to offer an apology at this point for covering some of the same material we have covered previously. That sort of is how it is. I've provided a very short legal submission. I'm not proposing to go through that at all, but to some extent through the hearing process, we have been building up to the presentation of particularly the noise case and the noise control boundary, which I'm not wanting to suggest other issues aren't important, and particularly the proposed Clandeboy dairy manufacturing zone is sort of an issue in itself as well. But alongside that, noise is probably, not surprisingly, one of the key issues and effects arising from Clandeboy's operations. Probably just worth recapping a little bit on that sort of broader context as well. So post-hearing B, there was some expert caucusing that went on between Mr McClellan and Ms Tate with regard to the provisions. And I think in a nutshell, the provisions in and of themselves are agreed as between the two experts, appreciating that's not binding on the panel. We still have an outstanding issue in relation to whether it should be a general industrial zone with a precinct, or as Fonterra proposes, a Clandeboy dairy manufacturing zone. And I've covered this in previous hearings and it's been in previous evidence as well. I think ultimately, and I've said this previously as well, substantively, at the end of the day, there may not be much difference between the two. I think, practically speaking, and sort of in terms of the utility of actually using the plan, having a Clandeboy dairy manufacturing zone makes sense. It sort of demarcates it as being something different than a general industrial zone with a precinct where you end up with a whole raft of ghastly tag-ons onto the various provisions. So Again, substantively, I think neither here nor there, but I think in terms of actually usability of the plan and how it presents the zones to be preferred. Reason for probably noting that is the noise control boundary is something different again than the Clandyboy Dairy Manufacturing Zone. And that's set out in evidence, but probably in terms of this hearing, the other thing I'll just note in terms of very brief introductory comments is Fonterra obviously also has a significant interest in the Port of Timaru operation, so it's got 75 staff in its facility, or up to 75 staff. And I think it's hard to get your head around the sense of scale of this, but for the 2022-23 season, there was 76,000 containers that went through the Port of Timaru. So that's a really substantial operation in and of itself. Fonterra doesn't own its Port of Timaru facility, so that's owned by Property Income Fund Number 2 Limited, who I think are appearing separately in this hearing. The relevant experts have worked a little bit to ensure the relevant positions, not surprisingly, are aligned as between particularly tenant and lessor in the case of the Fonterra site, but more generally to make sure that that's consistent with the wider context. So on the issue of noise, and again you've heard from me on this a lot before, so the very blunt starting position is it's not possible for Fonterra to totally internalise its effects. The panel's been to the site, it's seen how it operates. Fonterra is very conscious of minimising its effects to the extent it can. And then we get in sort of, which is probably more Mr Hayes' domain, but a discussion of various sets of numbers. And I think the starting point for this hearing is Fonterra actually holds an existing consent. It would have actually been granted back in the Alpine Dairy days in the 90s with regard to an existing a noise envelope from the site. So that's and I don't pretend to personally understand the difference in the numbers, but that's an L10 55 and a daytime and a nighttime of 45. That's in effect, again, as set out on evidence, a noisier noise environment than what we now talk about in terms of the district plan LAEQ or just more generally. So the existing consented envelope is a little noisier than what we're actually proposing with the noise control boundary. The alternative obviously would have a noise control boundary, and that would mean that, again, depending on what label the zoning ends up with, but we're assuming it would end up with the industrial noise limits of 50 and 45 LAEQ at the notional boundary within the rural zone. Now, practically speaking, at least as far as set out on evidence, there has not been development within the rural zone around the site for basically this century. We are, however, very conscious that the noise control boundary really does two things. One is that we think quite rightfully so, puts a clear envelope around Fonterra's own operations, and so it knows if it's doing future development what that noise contour looks like and what cannot be exceeded, at least without a consenting pathway ensuing. And it also gives notice to anyone who might want to build a dwelling or do dwelling amendments that I know in a practical sense it may be obvious because there is a big dairy manufacturing site there, but in a real world sense it alerts those people to the fact that they may experience noise that exceeds the district plan standards, in particularly as they would otherwise apply to an industrial site. So because Fonterra's already got a consented environment, in a strict legal sense we're not taking anything away from those people. Fonterra is entitled to emit noise from the site at the moment, but it's really just putting, again, that's in the context of a plan, of a consent that's now a short bit of paper that's 30 years old and I think not readily apparent to the general public. So bringing that a framework through to the district plan that's actually more onerous on Fonterra than what the consent entails sort of makes sense. In the real world, it puts them down no more than a permitted activity pathway with a requirement to ensure they are considering installation in their build or, I guess, renovation or major amendment to their dwelling. And from what I understand from the technical evidence, that's not a particularly costly or onerous imposition on those landowners. So ultimately, in that context, is about managing reverse sensitivity effects. But again, it's sort of, as I said, the other important purpose is just ensuring the Fonterra operations in and of themselves don't get away on everyone and result in further noise than anticipated. So a lot of my work, but I do a lot of Fonterra work around the country, is talking about NCBs. So it's been a slow process for Fonterra over a number of years in terms of turning up to hearings like this and talking about NCBs. So I think we've got 16 out of 23 sites now covered by noise control boundaries. So it's now become a relatively orthodox thing in terms of processes like this and people getting their head around what it actually means. And certainly wanting to put one on the Clannyboy site for the reasons we talked about. That was probably what I wanted to cover on noise. The only thing I just touched on legal submissions, which I'll cover off, is there was a couple of, which I'm not going to talk to in any detail, there were a couple of bores identified in relation to potential sources of drinking water and whether they needed protection. Now that's actually an error, so that wasn't picked up in the submission stage, so we're just proposing that that be done as a Schedule 1 Clause 16 amendment. I think the officer's in agreement with that general approach. I don't see that as contentious. There's no prejudiced party other than potentially Fonterra, so just wanted to note that as well. So that's all I had. I've got Mr. Hayes, probably the logical, if you've got questions for me, fire away, but as I said, you've heard from me a lot before, so yep.
Sorry, I so don't know who to ask questions to. In this hearing, there's so many people and so much evidence. Mine is just with regards to Ms. White's section 42, and it says in here that Fonterra's noise expert and Mr. Hunt will get together before the hearing, and that Mr. Hunt is generally supportive of the requested NCB and associated planning amendments. He considers that further information is needed to confirm this position. And I just wondered if that occurred and if that information has been given. Yeah,
that's a good question in terms of process behind the scenes. So I think Mr. Hunt raised a number of that. They weren't necessarily concerns. I think philosophically Mr. Hunt understood the purpose of the NCB, but there has been a process underway with Mr. Hay and Mr. Hunt. Ms. White's 23 April summary statement records the position reached in her paragraph 8, C and D particularly. Long story short, I think all the concerns have been resolved, and as between the relevant experts, there's now acceptance or agreement, whatever the appropriate phrase is, in terms of the use of an NCB. But perhaps Mr. Hay can talk to that a little bit more if we want to. Yep. Maybe I've saved him a question, I'm not sure. But.
Sorry, it's been a bit of a day going back and forth online, but...
I'm so sorry.
All right, perhaps we'll now, Mr. Hay, if you can...
Good afternoon. Where would you like me to start? Do you want me to read my whole evidence or Thank you.
No.
Excellent.
Just give us a quick a refresher on where you've landed.
Perhaps if I read the summary of findings. My evidence is in two parts. There's the Clandeboy part and the port part. So I'll just quickly run through the summary of findings for both of those. So Fonterra currently operates under a resource consent that permits stipulated noise levels at the notional boundary of existing dwellings, and those are dwellings that existed at the time the consent was granted. These noise levels are essentially 5 decibels greater than the proposed Timaru District Plan limits. It is not possible for Fonterra to internalise its noise levels within the proposed Clandeboy dairy manufacturing zone. Should a new or altered dwelling lawfully established near the site, Fonterra would be unable to comply with the proposed district plan noise standards at that dwelling's notional boundary. At present, this would result in new dwellings experiencing noise levels greater than the existing resource consent of 45 dB LA10 at night, or the proposed PDP nighttime noise limits. This is not a desirable situation for Fonterra, council or possible future residents, as the exercise of permitted development rights may create a reverse sensitivity effect in which future residents unaware that Fonterra is permitted to make the current noise level seek remedy from Fonterra and council. To prevent this reverse sensitivity effect, it would be appropriate to establish a noise control boundary around the site, along with a set of appropriate controls over noise emissions and building controls such as sound insulation rules on new or altered buildings that include sensitive activities seeking to establish within the NCB. The concept of an NCB is well established and nationally proven framework that would protect Fonterra's ability to operate on its established and mature site, while providing certainty to council and the local community as to where future noise level effects lie and how these will be responded to. And if we turn to the port, and that section is mercifully brief. In essence, the way the proposed port rules and zoning have unfolded, it's created a situation in which Fonterra's nighttime operations at their leased facility would breach the nighttime noise standard at one of the new zones. And so what is proposed is a specific rule that acts as a bridge between the port noise contours, if you like, which apply only to the port and the port Z zone in which the Fonterra activity lies, that would enable those nighttime activities to occur, but at a reasonable level and with restrictions. And my understanding is that the Section 42A report has recommended accepting this submission in a slightly different form to the way we initially proposed it. And I note that I think an unintended consequence of splitting this rule for Fonterra out and putting it separately was that it missed the need for a daytime limit as well. And Fonterra has no wish to have an unlimited daytime noise level. And so Fonterra is proposing a 55 dB daytime limit, which is consistent with the existing zoning. So I'm in your hands with any questions you may have. I do have quite a section where I discuss the additional information that Mr. Hunt was looking for, but really the questions you've got for me.
I want to refer to your graphics, please. I've got a couple of questions about that. Are the only buildings within or on the 50-metre noise contour is the preschool and the residence at 110 Donahue Road being on the actual boundary?
Sorry, did you say the 50 contour?
Yeah, the 50-metre contour.
The 50 dB contour.
Yeah.
Yes, so there's the preschool, and there are currently 4 Fonterra-owned properties that are within that 50 contour, yes.
Does that include the property at 110 Donahue?
No, 110 Donahue is on the, pretty much sits right on the 45 contour.
Yes, okay. And in figure 3, there is a yellow dot depicting a dwelling existing in 1998, located in the settlement, in the Clandeboy Settlement Road.
Yes.
Is that one owned by Fonterra?
No, that's not. If you go back to figure 2, you'll see that that one is 62 Clandeboy Settlement Road. And that is one of our monitoring locations, and every time we've monitored there, we're actually measuring a compliant level that is compliant with the consent, so below 45. But our prediction model consistently places it at around 46, 47 dB. And the reason for that is the noise from the tanker park. So what we believe the case to be is that our assumptions about activity levels within the tanker park during the nighttime period are a little bit conservative. In other words, we're over-predicting tanker noise, but in reality, that doesn't occur at that time of night. It's a bit more stretched out and sporadic.
Okay. I think I've got... And then in paragraph 27, you talk about the voluntary noise control boundary. Has that proven viable for Fonterra?
27. Yes, it has. It hasn't always been particularly easy. There are times when we've had to do quite a substantial amount of design work and backwards and forwards with Fonterra, but they, since 2020, when talk about the district plan first came about and we began to investigate the NCB, the internal policy decision made by Fonterra was that they would try and live within the NCB that we modelled at that time.
Right.
And since that time, there have been a number of major additions and alterations to the plant, and we have been able to design those to comply with that NCB, proposed NCB.
That's good. Has the voluntary noise control boundary proven helpful to those 2 close properties mentioned in your paragraph 25?
I think because of the nature of the development that has occurred since 2020, that would have had very little impact on 110 Donahue Road, but without a doubt it has capped the noise level that is experienced at 62 Clandeboy Settlement Road.
Okay.
And in fact some of the other properties sort of towards the southeast, I guess, southwest.
Okay, thank you. Thanks, Mr. Hay.
You're welcome.
Thank you. Mr. Hay, can I just ask you a question about the performance standard for the insulation requirement? We heard from Kiwi Rail and Dr. Charles earlier this afternoon, where he, in relation to rail noise, he was advocating a different approach than what's proposed in the district plan. He's looking for he describes it to be, rather than specifying the sound insulation that is required to be installed in buildings affected by rail noise, a resulting internal noise limit is specified. So as I understand your evidence, you support the proposed plan standard. Do you have a view on whether or not, in the context of the Fonterra noise control boundary, it would be preferable to have to specify an internal noise standard rather than have prescription around
It's a really interesting question, and it gets, at a higher level, this sort of thing gets debated around the country constantly, and some districts and consultants prefer one method and some prefer another method, and they can both be made to work. The thing about an internal level is that in order to design your building to achieve that internal level, you have to know what the external level is. And that means that if someone came along and decided they were going to build a house inside the NCB, they would need to either get an acoustic consultant to go and measure the noise at that location, or they would have to contact Fonterra and ask if Fonterra would tell them what we model the noise to be at that location, and then they'd give that information to their acoustic consultant who could do the facade design. The advantage of just providing them with a facade design requirement is that it takes that whole step out of the loop. They can just go away and do the design and say to council, here's a report from our acoustic consultant, this is what we're doing, it meets your requirement.
That's helpful. And I don't have any other questions in relation to the acoustics. Thank you for that.
Okay, thank you.
Thank you. So we've now got Ms Tate, who I should add obviously covers a few other issues, as I said at the beginning, not saying they're less important, but sort of is a little bit about noise. But she also covers noise. Yeah.
I will try not to labour anything, but I'll come to noise last, perhaps. I think that's where there's still one outstanding issue to go over. So my evidence, I'll just cover off where I think that some changes might be warranted to what's been put forward by the Section 42 officers. So natural hazards, I'm generally supportive of what Mr Willis has recommended, but I do wonder if the amended definition of natural hazard sensitive building, I guess, has swung to be a bit overly conservative, I guess is the concern. I appreciate that a proxy or proxies of some of some sort is required, and I guess my recommendation is that both a floor area and a staff number is used, and I guess the key point I'd like to make there is that the natural hazard process, or where you put your buildings, there's already a rule to protect the neighbours and the flow of land onto their property. This rule is really about protecting people and property on the site, so it's almost about the council trying to protect people from themselves. Landowners and developers, they are able to make these determinations themselves, and I suspect would do so in the case of Fonterra, regardless of what was in the district plan. So I guess I just wanted to make that point. Please interrupt if you have any questions on these particular topics. There was nothing stand out on versatile soils or the coastal environment. Earthworks, Fonterra's original submission sought to remove Clandyboy from the earthworks requirements because it's a large, already largely developed site, and that would fall within the gambit of the regional council, large-scale earthworks would. And then on reading Ms Williams' report, I acknowledge the exclusions in Rule 1 of the chapter, but I guess I still have an outstanding concern about the exclusion with regards to earthworks that already have building consent. Oftentimes resource consent would be sought ahead of a building consent, and so for the Fonterra site, it's a 2,000 square metre limit. Anything within a building footprint would be excluded, and so may not be needed if the building consent had already been sought for it. But if it didn't have a building consent, it would have to go through a resource consent process. So it just feels like a duplication of the process. So really my recommendation there is just to try and avoid a duplication of the process. Drinking water protection, Mr. Williams has already covered off the minor change that Fonterra is seeking about the bores there. Light, Ms. White and I are in agreement based on her summary that came through at the beginning of the week. I'll come back to noise, and then I think the last issue was signs, and there's nothing really substantive there either. So with regards to noise, I guess I'll just start by saying Ms. White and Mr. Hunt and Mr. Hay, I think we're by and large on the same page. I think there's one outstanding issue from what I can discern from Ms. White's summary, and that's the activity status for noise-sensitive activities within the Fonterra noise control boundary. If the Fonterra site is added under Rule 9, then it would default to a restricted discretionary status. And my position is that it should be a non-complying status. I am not convinced that a restricted discretionary activity status is sufficiently deterrent to let people know that noise-sensitive activities in that location without appropriate insulation is appropriate from an environmental health perspective, but also from a reverse sensitivity perspective. So there is obviously a dual function to the noise control boundary. And I guess leading into all of that, there's two policies that relate to reverse sensitivity in the chapter. One is sort of a generic reverse sensitivity policy, and the other relates to the existing noise control boundaries within the proposed district plan. My position is that if the Fonterra site or the Fonterra noise control boundary is referred to under both the policies, then a cascade from a permitted activity status for an insulated noise sensitive activity to non-complying status is appropriate, given the wording of the two policies. So I think that's the only area outstanding between Ms. White and I. I'm happy to take questions.
I'll start, and I'm going to start with the same question I asked Ms. White this morning. What matters other than noise would need to be considered if a resource consent was required in terms of the insulation, the noise insulation?
What other matters?
Yes.
I guess, well, the rule actually provides for methods other than insulation. Insulation is the primary one. You can also seek a consultant to confirm that, I guess, we'll say standard construction under the building consent process, which I understand from Mr. Hay would by and large actually satisfy the insulation requirements anyway, so it becomes a little bit circular. If that standard was triggered, I guess there's location within the site, so if you're not going to look at insulation. So if you were restricted discretionary, is that the question? What would you consider?
No, if what matters, yeah. So in terms of because non-complying, there's no limitation on the matters you consider.
Yes.
If you if you aren't providing the noise mitigation, I want to know what other effects need to be considered. That's what I'm asking. What matters other than noise, and those matters of restriction relating to noise, should a consent applicant have to address? That's my question.
I don't think that I don't think that a non-complying activity status, so restricted discretionary, I think what you're getting at is you can isolate the issues through matters of decision.
I'm purely asking you, what matters other than noise do you think should be considered as part of the consent?
If it was a non-complying activity?
Yeah. Or any activity status other than RDA, which specifically relates to noise. So what are the other matters?
I don't think that there would be, I mean, there could be setback requirements under the general rural zone, but in terms of that standard, I don't think that, I mean, it's a noise standard, so it would be triggered for noise reasons.
Right. So the reason for non-compliant activity, from your perspective, is purely about the message it sends, rather than the need for a broad assessment to be undertaken by a consent holder?
I think there's a policy framework already in the plan, and the so the proposed plan already has all of these provisions in it. Fonterra is just coming along and asking for a noise control boundary. So defaulting to a non-complying activity status is already, when you're in a noise control boundary, is already a mechanism in the plan. That's what happens for the airport and that's what happens for the raceway. It's restricted discretionary within the inner port noise control boundary, defaulting to non-complying. Interestingly, there's different matters of discretion for being restricted discretionary in the inner noise in the port in a noise control boundary than there is for Rule 9 or the standard that it defaults to. So the idea that it becomes non-complying because that activity is inappropriate in that location when there is a known elevated noise level already exists within the plan.
Yeah.
So I think in this case, I don't think it's a deterrent. I think it sends a message that it's appropriate. And I think it has, as I said before, I think the noise control boundary has a dual mechanism. It is protecting individuals, particularly in this case when Fonterra already hold resource consent to emit these noise levels. So it's not about putting people off, it's about protecting them and protecting Fonterra from reverse sensitivity. So it's, I did use the word deterrent before, I think that was the wrong word, but it is about, it is a messaging, a non-complying activity status is saying that that type of activity is inconsistent with the policy, which it is, because it already is in this plan.
That's not true though, is it? Because you can pass the gateway and it could be entirely consistent with the or not inconsistent with the
Sorry, I'll rephrase that. If there's an avoid policy, which there is in this case, then it's typical to have a non-complying activity status.
Right, okay. So I think you've probably answered my next question, which was, is there any deficiencies from your perspective in either the objective, policy or matters of discretion that would apply to, let's say it was a restricted discretionary activity? Are there any gaps that you don't think the plan currently covers the matters that should be considered if somebody did breach that standard, if it was a Rule 9?
I think that the two issues is that if the building wasn't appropriately insulated or located or directed or whichever method of management was chosen, then the occupants would experience noise levels that are already above the district plan, what's expected by the district plan, because Fonterra hold consent for it. And the reverse sensitivity doesn't happen until it happens, if that makes sense. So it only arises if someone chooses to take issue and lays a complaint. And so I think in my evidence, I made reference to Ms. O'Rourke's evidence from Hearing A. Sorry, I'm just trying to find it. Reverse sensitivity effects generally result from complaints by just a few residents. The effect of such complaints can be as significant as leading to a reduction in operating hours at a site and therefore a loss of productivity. Due to Fonterra's legal requirement to accept milk, this can have significant operational issues for the site as a result of the reverse sensitivity complaints. And the bit that I haven't got there is that often those complaints are on a permitted activity or a consented activity.
Yes. Right, I suspect we might be talking slightly past each other.
Sorry, so the matters of discretion...
What I'm wanting to know was if it stayed a restricted discretion, so
yes.
If it stayed, as Ms White's recommendation
yes.
is the objective and policy and matters of discretion regime in the plan sufficient from your perspective to address the matters that would need to be addressed through the consent?
No, I don't think that the matters of discretion are sufficiently, well, I guess the point I was trying to make was the cat's out of the bag, someone's already built there, and then the reverse sensitivity effects start.
But if they're applying for a resource consent, so they're applying for a restricted discretionary activity, what additional matters of discretion, if you think they're deficient now, in terms of the activity status Ms White's suggested, what other matters of discretion should we be putting in the plan?
I don't think that there are other matters of discretion, because I think that someone could say, I won't complain, I know I'm in the noise control boundary, it will all be fine, and then they exist there, and then they do start complaining. Matters of discretion aren't going to resolve a grant of consent to say, oh, you can go there.
But aren't you assuming, so your assumption is that someone's going to apply for a restricted discretionary activity consent and they're going to get granted it with nothing. Is that what your assumption is? I just don't quite... I think I'm struggling to understand the question. Do you understand it, Mr Williams?
Yeah, I think I do. I think what you're driving at is, would the matters of discretion in an RDA rule contemplate other matters of control other than noise? And I think simplistically the answer is no, it would be noise. I think the issue here is the higher level consideration of is an RDA activity in this instance appropriate given the objectives and policy overlay and what we're trying to achieve. Now, I was trying to find it then. The old case I normally cite with this is Dunedin, Doherty and Dunedin City Council. I think it's called an earlier Smith judgment, where Judge Smith basically talked off the virtues of discretionary in that case, but same difference, and non-complying, and the basic premise being that discretionary activities are normally matters that the grant is contemplated from time to time, and I think in this instance we are saying the grant is not contemplated, i.e. a dwelling which does not comply with an insulation standard. So therefore the non-complying, or more fundamentally the Section 104D test, is it consistent with the objectives and policies, or are the effects less than minor, appropriate? And I think that's where I see the rubber hits the road in terms of the real issue. I answer your question, RDA about noise will obviously and always address noise. So.
Right, yeah, thank you. Okay, so then my next question comes, given that there is a difference in terms of what Ms White was recommending of a RDA, when I looked at and you're seeking a non-compliant, when I looked at your Section 32, it covered the noise control boundary and whether that should exist, but I may have missed it. There was nothing that I could pinpoint around the appropriate activity status within that. Have I missed that somewhere?
No, I don't think you've missed that. I didn't discuss. I was working on the basis that I didn't cover it explicitly. I was working on the basis that if it fell under Policy 7, an avoid policy, then a non-complying activity status is appropriate if that policy is amended to include the Fonterra.
Thank you.
I would like to talk about signs. I went down a rabbit hole with signs, and I...
Away from noise.
And yes, I'm going to move away from noise. I have 4 children, there's plenty of noise in my house. Signs. Well, now, I was talking to Ms Williams about it this morning, and as I'm a local, I went for a big drive around the port, and on Anzac Day, I went out to Fonterra and had a drive around. And I don't know if you've read the ports, what they are wanting and what your recommendations around your entrance. I'm just trying to find it. 1 sign per vehicle entrance was your sort of rationale, where the port, they also are in disagreement, and they're sort of referencing at least 2 freestanding signs, or ideally no limit is what is wanted, so status quo. So have you had a chance? Have you got any more views on that? Because at the moment it's still one sign. So,
in my evidence, I made comment to 1 per vehicle access or 1 per defined length. I think either of those would be what I have typically seen in planning regimes. I think that I'm not particularly wedded to either outcome,
no,
to be honest.
I think
1 sign per site when you're looking
yes.
at large-scale sites seems overly restrictive.
Yeah, because what I was trying to ask this morning is what is the actual issue? Because obviously I was concerned we were trying to, there was restrictions being done, but I couldn't see the reasons or rationales for why we were doing it. So
I think mostly it would be about directional signs, and probably from Fonterra's perspective anyway, making sure that the right traffic went in the right access. From a branding or business perspective, I guess at the port there might be different requirements because there's multiple businesses that operate within the port, and maybe on 1 single large site. I can't speak to that. So I guess 1 sign per site or site frontage just seems overly restricted. But I wouldn't say I'm particularly wedded to either 1 per road frontage length or 1 per... But if it excluded directional signs, I think from Fonterra's perspective, that would be, they might fall under health and safety signs, official signs.
Ms Tate, I don't have any additional questions for you. Thank you, and thank you for engaging with council staff directly to resolve as many issues as possible. Thank you. Ms Williams, unless you've got anything else to add?
That's it for Fonterra for the hearing process. So thank you very much for your patience with us. So
thank you very much for your evidence and submissions.
Thank you.
Got Mr Hall and Mr Mortimer are going to join us. Absolutely, that's great. Gentlemen. Oh, goodness. Brave the wet conditions out there to be here today.
Certainly have.
When you're ready, thank you.
Well, it was suggested when we last came that perhaps we'd only come once, but we thought, well, we might just annoy you a second time, but we're not quite sure why we're here, so that you'll be able to make up your mind at the end whether it was worthwhile or not. Well, I'm Matthew Hall and this is Bob Mortimer. We met before, but really what happened, if you just look at my notes there, someone put a line on, drew a map, and on that map they put the rangatata huts in a high hazard area. And according to ENH 01 or whatever it is, an area subject to high hazards, risks to human life and significant risks to property should be avoided. So that's sort of the basic premise. And the rangatata hut's sort of sitting in there. We appreciate, though, the fact that the tribunal have been down and visited the huts, and they'll be aware of the fact that even though the Rangitata River flows close by and the seafronts are reserved, the area is stable, and it is on high ground, and it's well above sea level, and currently there's no real immediate risk to human life or property, and that's even with the rain today. My family can go back 120 years at the Rangitata, and during that time, no property at the Rangitata Reserve has ever been washed away by the river or the sea. The area is gazetted under the Reserves Act for fishing huts and recreation, and there's currently 114 huts there, and they've got a value between 15 and 20 million. So that's where we're at the moment. The area is administered by the Timaru District Council, and as residents down there, we've got the expectation that the council will advocate on our behalf for the reserve. Quite frankly, we're not sure how visible that advocacy is, really. It's a question we'd have. The area was settled with buildings, and they were all permitted long before somebody came along and in their wisdom decided to say, well, this is a high hazard area, and the buildings in this area are non-complying. Most of us would believe that high hazards are really perceived rather than real. In recent years, there's been tsunamis from Kaikoura and the Japanese earthquakes, and they didn't flood the reserve. The greatest risk would be, in an earthquake, would be from Peru, and clearly if a tsunami originated from Peru, there'd be time to evacuate, and the reserve, if it was destroyed, well, then at that stage the choice would be to rebuild it. Currently, all that is hypothetical. And surely you would say, well, this plan isn't based on that sort of hypothesis. Surely it's not. The greatest risk to life and property down at the Rangitata is fire, without a doubt. And we're not talking about fire here, we're talking about natural hazards. And the issue with natural hazards is no one knows what is around the corner. Go back 120 years, jolly hard to go ahead 120 years. There's what you call the law of probability. And when it comes to our view at the Rangitata Reserve, an educated guess, which is, say, an expert, carries no more weight than an uneducated guess, because no one knows. And to show what I mean, I'll refer you to some hazard lines, and if you just go over a couple of pages, you will see a map of the reserve, and that's taken out of the Coastal Management Plan, and it's part of the Rangitata Plan, and it's got a whole heap of lines drawn across it. And those lines represent the coastal inundation line, the 100-year line, the 50-year line, the erosion line, the tidal line, or whatever you like. So there's a whole heap of lines being drawn on it. Now, they were drawn about 25, 30 years ago, and they're relevant today because they're part of the Rangitata Plan. And what's happened, of course, is around those lines, some rules have been put around those lines. Now, if the experts were right, 50 years ago, or 25 years ago, they drew a line. Or you say if the 50-year line, you should be halfway to the 50-year line. 25 years on, you should be halfway to the 50-year line. However, they're wrong, because what's happened is, in the last 25 years, In actual fact, the coast has got further away than closer. So, you know, you could draw a line, you put some rules around it, but, you know, you could be wrong. And what happened was, if you go to my point 12 there, two things intervened in the meantime that people wouldn't have thought about. In December 2019, we had a huge flood in the Rangitata. It put tens of thousands of tonnes of shingle out to sea. And the waves washed that shingle all up along the beach and built the beach up. So it actually added a protective bank, mainly because of one flood, you say, with global warming. One flood did that. And then there's been a number of floods, quite significant floods in the Opahe and the Orari, and all the slash and rubbish that comes down the rivers, those rivers, has been built up along the bank along the Rangitata. And that has had the effect of building up the beach significantly. So those two events have intervened so that made the, I would say, the 50-year line and even the 100-year line quite redundant. So if you just go to the pictures at the back, you'll see about the third one, and you'll see the sort of slash that's been washed up. So I put a picture there of the slash. That has all come from the Opahe and the Orari rivers, and it's effectively added a significant barrier. And if you look at that slash picture, you'll see that there's another layer of shingle outside the slash. So what happened was we had the slash out of the Opahe and the Orari, and then we had the 2019 large flood and put that shingle back out on top of the slash. So there's now a significant barrier at the Rangitata. And just to continue with my commentary, on point 13, with abstraction for irrigation and power generation, the Rangitata can often be flow at low levels for long periods of time. And this causes the river mouth to become strangulated, and sometimes it semi-blocks, and then what happens, we get a flood like could be happening now, and the water ponds back up in the flood, and it has been historically known to enter some of the huts at the north end of the reserve, so that's one area that we can get some water. But what we've got under point 14 is with ECAN, we've got an arrangement with ECAN where if there's any risk to the huts from this low flows in the river and the blocking of the mouth, we now open the river mouth. And just very recently, we took they picked that the river could flood, opened the mouth, and there's no flooding at all. So we've got this mitigation to avoid flooding. So the reserves never flooded from an active brae to the Rangitata, and some years ago a protective groin was built above the huts and the upstream side of the huts to divert water away from the huts. So we've never had any flooding down there. So the point I'm making is, given that the reserve has for some years now been fully developed, long before a decision to rate it as a high hazard area, there needs to be the opportunity to mitigate any risk to our investment, and that should extend to planning and making sure that there's no barriers in the way to allow mitigation to take place. So realistically, what are they hazards? They don't appear to be immediate. If there is a hazard like the Peru thing, civil defence is in place, and we've got early flood warnings. The hut holders feel that we'd like to explore some mitigation measures, but we fear that the non-complying, if you make something non-complying, you're starting behind the 8 ball, and that's what concerns us. Is the area's been designated high hazard, non-complying, and so you're starting behind, which makes processes in consenting pretty hard. So that's really the verbal part of the submission. I added some photographs, and I talked about the map and about the 50-year line and the 100-year line, and the fact that I believe they're redundant, but never mind, they're part of a plan, the coastal management plan. Then I've got a photograph of a hut, Now, that hut was built long before lines were drawn, but going through the middle of that hut is the inundation line. So poor Bill, he's 19, he's in poor health, and he wants to sell his hut, but he's got an inundation line running through it, and some rules wrapped around the line. But you can see the hut's miles away from the sea or the river or anything, but there's an inundation line runs through his hut, and it's non-complying. So poor beggar, you know, it's not easy when, you know, in a planning sense, the difficulties have been created, not really realistic. The hut's sitting there in the sun and it's ready for sale and would make a good home for somebody, or a good holiday home, but never mind, it's got a non-complying aspect. The next photograph is of the reserve itself, and it's taken from the back of the reserve, or the southern end of the reserve, and it looks straight down through the reserve, and you can see sort of a clear corridor of grass there. That's where one of the inundation lines runs around through that, clean through the middle of the huts. So, you know, again, the line was drawn, well, Bob and I talked, and we think from somebody in Wellington drew the line. Had no idea of what they were really doing. But you can see the berm in the area between the sea and the huts is significant. The actual erosion line, which is the line where it's active, where the green hits the shingle, it hasn't changed at all for 60 years, 50 years. It hasn't really changed. It could change tomorrow, but up to now it hasn't changed. I've talked about the slash, and the second last photograph just shows sort of a fence line, but effectively what it was there was a gully there, and the hut holders decided would do a bit of mitigation. So the gully used to flood a bit, and used to flood back onto the reserve. So the hut holders, at their expense, put a bit of a bund up, and since that bund's been there, it hasn't flooded. So what I'm saying is even some small mitigations like that particular mitigation can help. So I'm a bit keen to work on some mitigations along the reserve to perhaps so that it lasts for another 100 years. So that's the mitigation that took place, effective. And then the last photograph, you can say, what's that of? It's of a gully or a swale that runs between the sea and the huts. It's a swale that runs right along. Now, 2 or 3 years ago, I did a survey of hut holders, and 30 respondents, all of them said, well, what we would like, if we had an opportunity for mitigation, we would like to keep that swale open. Because what happens, the sea overtops, the water runs down that swale, back out into the river and out to sea. So we would like to think that when we deal with the Timaru District Council, not particularly here, but that we have the opportunity to mitigate, to keep that swale open. Now you see that swale is nice and clean, there's no rubbish in it. And what happened is it did get full of slash, but ECAN came along and we had an arrangement with them. They cleaned it out, and so that swale's been kept open. And so that's one of the main mitigation measures we'd like to think that stays in place. So really, we've got really nothing much to talk about, but thought we'll take the opportunity to come along, say the place is not going under at the moment, but we are concerned about non-complying and the fact the area is high hazard, but it's not really. Yeah.
Just further to those inundation lines, etc., etc. If I go back probably 20 odd years ago, there was a chap out of Bats that he'd sold and another person moved into it, and these lines had been drawn about 2 years beforehand, and he came to the council to get a permit to do some alterations, which was the right thing to do, and the council refused the permits for him to do it. So he went to his lawyer, and further down the side, he actually ended up in Wellington, and I think it was, from memory, it was the old Lands and Survey Department in Wellington, and he actually ended up talking to the person that actually drew those lines. And he spoke to that person, he said, what was your criteria to draw the lines out at the Rangatahi huts. And he said, I don't even know what the Rangatahi huts are. He said, I was tasked with drawing lines around New Zealand, and that's what I did. So he got a statement from the person that he was talking to. He came back to his lawyer came back to the council. I'm not crying the council down or anything like that. Come back to the council, and within 3 days he had his permits to do his alterations. So those lines, and they're still the same, were drawn 25 years ago, and the person that drew them has never ever been to the Rangatahi huts. So yeah, it's quite confusing when you talk to people. How they ask, how did those lines come in? We can't really answer it. So we thank you there for the opportunity to speak. We were told that we probably didn't need to, but what we wanted to do was just cover these points so that you can read something on paper, but if you hear the stories behind it, I think it's a wee bit more covering, if you like. Yeah.
Thank you. I'll just see if there's any questions.
I don't have any questions, but thank you so much. When you do come, you educate us more, and we do appreciate it. So thank you for making the time to come in. And I know it's very wet out there today, so and the road. I see there's a warning, so make sure you travel back safely too.
Thanks. Yes. I said to my wife, I'm coming straight down here and going straight home. I'm not going to mess around.
Yeah, and thank you. It was nice to see you again, and good to have that in writing as well. Thank you.
Right, thank you.
Thank you. Well, that brings us to the end of today's session. Ms. Vella, was there anything you wanted to raise before we adjourn for the evening, or? All right, we'll resume tomorrow morning at 9 a.m. Thank you.